Good morning. The Senate Judiciary Committee will come to order. Today is Judiciary and Public Safety Committee will come to order. Today is Friday, March 10, 2023, and we do have a quorum present. Members, thank you for being here and anticipating a robust and productive and maybe long day, depending on how things go. We will have a great agenda to move through committee today, so I appreciate your patience and your kind attention. We're going to start with House File 45, Senator Mitchell. Why don't you go ahead and describe your bill? Welcome to the committee.
Thank you, Mr. Chair. Of all the things I have, I think this is going to, that I'm carrying this year, I think this is going to be the easiest and hopefully one of the fastest. I have bipartisan support for this. This sailed through the House. There was in 2021 a bill that went through, also bipartisan, for restorative justice for veterans. So basically, if a veteran had an issue like PTSD or something that hadn't been addressed, and somehow there was a correlation to them committing a crime. So for example, they were using drugs to self-medicate because they hadn't gotten treatment and they committed a crime. You can go into this process where you get help properly and then your guilty plea is put off, basically. So this has been working. I've talked to some of the people. I could have brought them in to testify today, but there's some really amazing stories coming out of this. The issue is this is a technical fix because as it is being applied, it has been, the way it ended up being written was a little confusing, and most importantly, clarifying that the correlation hearing, so to speak, would be before adjudication, so that they know going into this process whether or not they will be eligible for the program. So that kind of impacts how they might proceed in their proceeding, if, you know, if they know that they're able to plead guilty and then get into this program. So this is just a fixer. I have two people, if there are technical questions, to help me out. They don't plan to testify, but that's what we're doing today. Thank you, Mr. Chair.
Thank you, Senator Mitchell. Is there anyone else in the public here who wants to contribute to this conversation with testimony? Members of the committee, we do have a couple experts available to answer questions, if there are any. Senator Mitchell, I think this is really important. I know when people go into DWI court, they get a chance to find out before they make the year-long or so commitment to the court, and its benefits and its downfalls if you're not able to do it successfully. They know whether they're going to qualify to be in the court. This does seem like not only an oversight, but a wise repair to the veteran statute. I've got several clients that have utilized the new veterans procedure, and they're all better off for it. So,
yes, sir.
Thank you for bringing this along.
Mr. Chair, if there's anything,
Senator
if there isn't anything, I would love for this to go to general orders. That's what it did in the House, and I think it would be nice to get this fixed right away.
So, Senator Mitchell, my notes indicate that it does go from here to the floor. There aren't any other committees that have asked for it. Senator Westland moves that House File 45 be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed?
Aye.
The motion prevails. Thank you, Senator Mitchell.
Thank you, Mr. Chair.
Testifies for being available to us. I should make a note. We do have remote participation in this hybrid committee here today. So if you hear voices over the audio system, it is not God. So we can disabuse Senator Howe of that notion very quickly. But we are participating in with hybrid, and Senator Howe will be with us for as much as he can, and there may be others, I'm not certain. We will have staff monitoring the remote access as well. So for those of you who are participating remotely, we'll try to catch it if you raise your hand on the screen. But if we don't, and we're about to move on to something and you had a question, please just say something so we can have your participation here with questions or comments during our discussion. All right, Senate File 3, Senator Boldon. Welcome to the Judiciary and Public Safety Committee. Voter registration provisions modification. We are going to take this up, members. There is an amendment in your packet, but this is not the first stop for this bill. So why don't we hear a description of the bill, the portions of it that are relevant to the Judiciary Committee, and then we'll take up the proposed amendment. Senator Boldon.
Thank you, Mr. Chair, and good morning, committee members. I'm grateful to be here before you today with Senate File 3. This is a comprehensive democracy bill that defends, strengthens, and modernizes Minnesota's best traditions of voter participation, of sound elections administration and trusted local elections officials, of transparent government, and of grassroots campaigns and voter and local donor support. This package of common sense solutions rests on the premise that our state works best when Minnesotans' voices are at the center of our democracy. All Minnesotans benefit: Black, brown, Indigenous, white, Metro, Greater Minnesota, rich and poor, Democrats, Republicans, independents, and those with no party at all. We all benefit when Minnesota voters, not corporations or national forces, are at the center of our democratic process. We have certainly seen our democracy tested in the last few years. We've seen a rising climate of disinformation and rhetoric and fears of intimidation. Threats and intimidation of voters and election officials has been on the rise across the country. And we just passed the 2-year anniversary of the deadly insurrection and attack on our Capitol, the dangerous consequences of the rise of disinformation and harassment targeting our elections. This last election also highlighted the problems Minnesotans have been asking the legislature to tackle for years. Ever more money in our elections, dominated more by big donors and outside spending. Since Citizens United a decade ago, there's been an explosion of spending by outside groups, by independent expenditures that are not accountable to the voters or the candidates.
Sorry, can you pull the mic a little closer?
Yes, certainly.
Thank you, that's much better.
By independent expenditures that are not accountable to the voters or the candidates, and in many cases, voters and candidates may not even know who's funding them. So this bill responds to the urgent and the overdue, with reforms to make our system more accessible to Minnesotans in 3 ways. First, it defends voters and strengthens the freedom to vote for Minnesotans. It modernizes and expands voter registration with automatic voter registration and allows 16 and 17-year-olds to pre-register so they are on the rolls when they turn 18. And it ensures equitable access to opportunities to vote early, absentee, and in person. With these provisions in place, our dedicated elections officials will have the tools and resources they need to ensure that every eligible Minnesotan can confidently cast their ballot and vote in safe, secure, and smooth elections. Second, it protects Minnesota voters and our democratic institutions. It includes a strong provision to protect voters and election officials and election volunteers from intimidation and harassment. It also provides Minnesota voters the instructions and support they need to vote in the language they need it. And third, it empowers Minnesota voters, not corporations, in our elections. It closes dark money loopholes and increases transparency, as well as prohibits foreign influence corporations from spending money in our elections. So in closing, Mr. Chair and members, this is a critical moment in our democracy. When democracy was squarely on the ballot in 2022, Minnesotans of every race, generation, region, and background turned out not just to cast their vote, but to protect it. Voters sent a powerful message. They reject the extremism and efforts to undermine our democracy and want us to take action to protect democracy and ensure that all people have a say in the decisions that impact their lives. So with that, Mr. Chair, I welcome the discussion and questions, and at the appropriate point, I'm happy to discuss the amendment as well.
Okay, so members, we're going to have Counsel Backus identify the first provision in the bill that falls within our jurisdiction relating to combination of civil and criminal provisions, and then Senate Counsel Primo, who is joining us online, is going to identify the provisions for us that are purely civil in nature, and then we'll take it from there. Mr. Backus.
Thank you, Mr. Chair, members. As far as the criminal provisions are concerned, I identified essentially 3 of them. Article 1, Section 4, which is, I would characterize as mostly a conforming change. And then on page 10, subdivision 7, that's kind of conforming / clarifying, I would say. And then on Article 2, Section 2 is a substantive criminal provision that also has civil issues as well.
Ms. Primo, are you with us?
Mr. Chair and members, I am. Can you hear me?
Yes, we can. Would you please proceed to identify the civil law proceeding or provisions that are before this committee today?
Mr. Chair and members, the civil law jurisdiction falls under the data practices provisions as well as civil remedies. So the data practices provisions are found in Article 1 at sections 1 on page 1, section 7 on page 5, and section 8, which begins at page 6, but the specific provisions are mostly at the bottom of page 7 in subdivision 3, which relates to transmission of certain data to the Secretary of State. And similar provisions are in subdivision 4 for the Department of Human Services transmission of that data. And then on page 10, at lines 1015 to 1016, that data, some of that data is classified as private for ineligible voters. And the pieces on civil remedies are found in Article 2, Section 2. This was partly identified by Council Backus too, at page 19, and that goes on to the next page at page 20. Thank you.
I'm going to ask, before we go any further, if any members of the committee would like any further review of any of those provisions by council, or a re-identification if you didn't catch all of it as we were first going through it. Senator Kroon.
Thank you, Mr. Chair. My question is about on the last page, page 24, subdivision 4B, certification of compliance. I would submit that that's within our jurisdiction as well. It's penalty of perjury, also constitutionality.
Thank you, Senator Kroon. Anyone else on the committee have any questions or want to identify anything else? Senator Limmer.
Thank you, Mr. Chairman. I would like to introduce the A61 amendment.
Senator Limmer, let me just, before we consider that, if I may, is it connected in any way to the, or have any impact on the amendment that the author is seeking us to add to the bill?
No,
Do you know?
Mr. Chairman, no.
I just want to make sure that we're
I thought we
working
were
off of
past
a
that.
completed document.
I'll withdraw that motion, Mr. Chairman.
Thank you. We'll come back to you with that,
Yeah.
Senator Limmer. Let's address the amendment that the author of the bill wishes for us to consider first. Senator Umu Verbatim will offer the A60 amendment for consideration before the committee. Senator Boldon, did you want to review your amendment, or did you want council to go through it for us?
Mr. Chair, I'm happy to do either way.
Okay, Senator Boldon, why don't you walk us through? Our council was not involved in the drafting of this amendment, so why don't you tell us what is you'd like us to do, and a concern that I have raised repeatedly in this committee, even though you're not here, you might not know it. Why is the Judiciary Committee the place where this amendment is coming before us? I'm reluctant to step on any other committee's jurisdiction with this.
Certainly, Mr. Chair. I'm happy to
Senator
walk
Boldon.
through it. Thank you. And I'll just note this is our fourth committee stop with this bill, and so it has been, we have been taking inputs and working on language as we continue through our path. So broadly speaking, this amendment is mainly technical and clarification changes that have been raised as part of the committee process to ensure the intent and operation of the policy language is clear. Most of this amendment is adding effective dates for the policy changes. The amendment also clarifies the transition to new voter registration applications, and the voter registration card of a voter who uses an old form is still valid, just validates that. It clarifies that the materials required to be provided in the polling place are the printed materials, and that it's the Office of the Secretary of State's responsibility to coordinate and effectuate the AVR mailing. I'm happy to walk line by line if that is desired.
Yeah, if you would please do that. Thank you.
Certainly. Lines 1.2 to 1.9 establish that the effective date of the pre-registration changes are June 1st of 2023. These sections require the updates to the voter registration application. The Office of the Secretary of State and local election officials would like to make sure that any changes to the voter registration and application happen concurrently, if at all possible, since it will require printing and distributing new forms. Further, because there are some municipal primaries in 2023, we want to avoid requiring them to print any new forms mid-absentee voting period, thus the June 1st date and not the July 1st date. Lines 1.11 to 4.3 simply break apart the proposed changes to the voter registration form into two sections of the bill and identify that they need different effective dates. While we'd ideally like to make changes at the same time, the permanent absentee voter provisions require programming changes to the statewide voter registration system and cannot be implemented until 2024. So this new language clarifies that the pre-registration changes to the language of the form are effective June 1st, 2023. The permanent absentee list changes to the form are effective June 1st, 2023. Lines 4.4 to 4.5 is another place where we are identifying that the pre-registration provisions are effective June 1st, 2023. Lines 4.6 to 4.13 are changes to the opt-out notice portion of automatic voter registration. This makes two changes. First, it requires that the state print and mail out the opt-out mailing. This was at the request of the counties. Second, it requires the opt-out notice to ensure maximum language access. At a minimum, providing a link to the Office of the Secretary of State website where the instructions would be translated to a number of different languages. This was at a request of community advocates representing new citizen communities. 4.14 to 4.16 removes language that limited the impact of this subdivision. While Senate Council noted that there's not a penalty in this section, so the language would not have an impact. 4.17 to 4.18 changes the effective date for making names of absentee voters public from July 1st, 2023 to June 1st, 2024. This aligns the effective date with the others related to permanent absentee voting and allows time for needed programming. Lines 4.19 to 4.24 changes the effective date of the Restore the Vote from July 1st to July 1st, 2023 to June 1st, 2023. This was identified by county and local officials that while the Restore the Vote bill said it was effective July 1st, 2023 and applied to all elections thereafter, they're worried that it would be confusing to voters because while the Restore the Vote would apply to the August 2023 primary, rights would technically be restored mid-absentee voting period. So this will avoid confusion about the ability to vote in the August 2023 municipal primaries and give counties sufficient time to update needed forms before that primary. Lines 4.25 to 5.4 say that a voter registration submitted on an old form is not invalid and prevents the Office of the Secretary of State or government from printing any old forms once the law has changed. Lines 5.5 to 5.13 simply clarify that materials required to be provided in the polling place are the printed materials, and the audio, visual, and electronic are required to be provided on the Office of the Secretary of State website. Lines 5.14 to 5.16 makes it clear that the effective date for these language requirement changes is January 1st, 2024, which allows time for implementation and production of the required materials. And then lastly, lines 5.20 to 5.22 makes the prohibited conduct regarding intimidation effective immediately. Elections occur year-round at various times in Minnesota, and we want to ensure those protections start as soon as possible. And that is the end of the amendment, Mr. Chair.
Senator Boldon, are these changes, do you know of any interested parties or stakeholder groups that are opposing the changes you're proposing in the 860 amendment?
No, Mr. Chair, I'm not aware of any opposition.
All right. We have the benefit of having the chair of the Elections Committee in our committee, Senator Carlson. It looks like the stuff that we have here is really not judiciary jurisdiction related provisions, and my approach to this would be if the Committee of Jurisdiction doesn't have any objection to us adopting non-controversial provisions, I'm okay with our committee taking those steps, but otherwise I don't want to get into any other committee's jurisdiction when making these decisions. So, Mr. Chairman Carlson, what is your view on the proposed amendment?
Well, Mr. Chair, this,
Senator
and
Carlson.
Senator Boldon, this is Senator Boldon's bill, and she is the author. And if she is agreeable to the changes, I would be agreeable to the changes. They appear to be somewhat minor, and I don't think we need to reevaluate them in the Elections Committee.
Is there any discussion relating to the A60 amendment that we have before us? Senator Cruan.
Thank you, Mr. Chair. I just want to clarify, I just heard that there would be no need for the Elections Committee to review this. I mean, I'm uncomfortable taking action on this. I think this is squarely within the purview of the Elections Committee, and if it's going back there for the Elections Committee to take a look at it, that's one thing, but I'm not sure if you could repeat the path that this is on and whether this is going to be reviewed by the Elections Committee.
Senator Carlson.
Thank you, Mr. Chair. And Senator McEwen, I'm looking at the changes now, and I don't think that we need to bring it back to the Elections Committee.
They appear mostly to be technical clarifications without any major substantive effect other than to make the system work a little bit more smoothly rather than being policy decisions. This is not my area, Senator Carlson. Would you agree with that characterization?
Mr. Chair, Senator Latz, yes, I would agree with your assessment of that.
So, Senator Boldon, on the amendment, page 5, page 20, line 29, this is at 5.17.
I'm sorry, Mr. Chair, 5.17?
Yes. The amendment proposes to make the change in effective date to make the voter intimidation provisions effective immediately. Normally, because this is, the voter intimidation provisions are criminal provisions, and normally we don't make criminal law effective immediately. In fact, we expressly disavow it as much as we can. And not to mention the civil remedies that are in there. So I'm a bit concerned about that. Can you tell me again why you believe this is so urgent that it has to be effective the day following enactment?
Yes,
Senator
Mr.
Boldon.
Yes,
Go
Mr.
ahead.
Chair, I appreciate the question. The decision to make this particular provision effective immediately is just because elections happen year-round in Minnesota, in different areas at different times, and we wanted to ensure that they started as quickly as possible to protect Minnesota voters. However, Mr. Chair, if it's the desire of this committee to, I'm open to conversations about that, I will say.
Senator Boldon, aren't there some laws in existence right now that prohibit voter intimidation that already cover some of this territory? Senator Boldon?
Appreciate the question. I would say yes, there are some protections for voters currently. This language is strengthening those.
Well, I, for one, am pretty uncomfortable having a criminal provision effective immediately or the day following enactment. Normally, August 1 is our effective date, right? Mr. Beckman? Senator Boldon, do you have any idea when the next election is in Minnesota? Anywhere in the state?
That is a good question, Mr. Chair. I think, I will just say that, we don't want to tolerate voter intimidation anywhere, anytime, but I appreciate what you're saying. I imagine there will be some summer primaries, so I believe August 1st is mid-primary, so would propose would ask if an August 1st enactment date would be more palatable for the committee.
And presumably, there would be some pre-election day absentee balloting that would also be taking place that we'd want to be able to cover, right? Senator Boldon?
Correct, Mr. Chair. I would believe so.
Senator Westland?
Mr. Chair, it's because August 1st is going to end up being sort of mid-primary, and obviously there's some concern with having this become immediately effective, maybe June 1st would be appropriate. It's shortly after end of session, but it also captures the fact that there is going to be some election activity taking place, and I think the idea is we don't want to tolerate voter intimidation at all. There's already a prohibition against it. This simply strengthens those provisions. So I guess my question, Mr. Chair, and maybe to council is June 1st an acceptable date? And if it is, I would make an oral amendment.
What is, to anyone who knows, what is the first date when absentee balloting can begin prior to an election day? Is that 45 days before an election or 30? Senator Boldon, do you know?
Mr. Chair, I believe it's 46 days.
46 days? I'm seeing Secretary of State's office heads nodding in the front row there, or the second row. So if there's an August 1 primary, if we were to have an effective date June 15th, that would capture most of that time frame. I mean, if this bill doesn't pass until the last day of session, which is theoretically possible, that would still only give 3 weeks notice. I mean, I'm a little bit less concerned because there's already some prohibition in statute against voter intimidation, but there ought to be at least some reasonable notice period that certain kinds of behavior is going to be subject to some new provisions in the law. Senator Boldon, would you be open to changing the effective date provision there to June 15?
Yes, Mr. Chair.
So I'm going to ask council to give us the specific language. Then we'll ask Senator Umu Verbatim to incorporate that into the A60 amendment, since she's the mover of it. Mr. Backus.
Mr. Chair and members, it would be an amendment to the A60 amendment on page 5, line 18, delete the day following final enactment and insert June 15th, 2023.
Senator Umu Verbatim, do you incorporate that change into your A60 amendment?
Yes, Mr. Chair.
All right. Is there any discussion about, any further discussion about the A60 amendment? Not seeing any, Senator Umu Verbatim moves adoption of the A60 amendment as amended by her incorporation with the effective date change. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. To the bill, then, so I do have Senator Limmer. Let's go back to you. You had an amendment.
Mr. Chairman, our last motion was to amend the amendment.
No, Senator Limmer, Senator Umu Verbatim incorporated the effective date change into her amendment, so the last motion was on the A60 itself.
All right. Mr. Chairman, I'd like to introduce the A61 amendment.
Okay, members, the A61 amendment has been distributed. Senator Boldon, do you have a copy of it as well?
Yes, Mr. Chair.
All right. Senator Limmer, is there any argument to be made that this amendment is within the Judiciary Committee's jurisdiction?
Well,
Seems to be a pretty substantive change, not just
the purpose, Mr. Chairman, is adding the identity, a political identity of a political party to a restriction that's already an existing law. The restriction prevents a contribution from going to other political entities, such as a candidate for the legislature, constitutional office, candidate's principal campaign committee, or a political committee or party unit. This adds the words "a political party." That would be the umbrella organization of a political party. And it does, if this is in law, this would fall under the 10A29 circumventions that are prohibited, which would be subject to a civil penalty. So I believe it would, Mr. Chairman, from a jurisdictional perspective.
Members, while we're having our conversation, we're also going to just verify whether or not our remote members have access to the amendment as well. But while we're doing that, and with Senator Limmer's explanation, let's have some discussion on it. But Senator Carlson, you've had a chance to review the amendment. And then we'll go to Senator Westland after that. Senator Carlson.
Thank you, Mr. Chair. And Senator Westland has some important information on this amendment.
Senator Westland.
Thank you, Mr. Chair. And thank you, Senator Limmer, for bringing this amendment up. We are in the process. This amendment was actually raised this week related to another bill. It is my understanding that there is another subdivision that also has to be updated, and not just this one, in order to accomplish the intent here. My understanding is that Senator Boldon is on that bill, and she is currently working with our council to incorporate all of the changes that would need to be made, again, to implement, I believe, what the intent is here. Because that work is already being done in relation to another bill that's still currently in elections, and And because apparently there's another subdivision in this section that would also have to be updated, I think that this is two things. I think it's outside the scope of this committee, but also I believe that this work is being done, and Senator Boldon is working to incorporate the amendment that was raised by Senator Curran in order to make sure that that all sections that need to be changed are in fact changed. For those reasons, not on the substance of this, but in terms of process, I would vote no on accepting this amendment here today, and allow Senator Boldon to work with council to make all of the revisions that need to be made, so that can be amended to another bill that she's working on in our committee.
Senator Boldon, to that point.
Thank you, Mr. Chair, and thank you, Senator Limmer, for bringing this language. I would recommend a no vote on this amendment, not because I disagree with the content. In fact, the opposite. I agree with the idea behind it. However, as Senator Westland mentioned, this conversation has been started in the Elections Committee, and I am in process of working on language in collaboration with Senate Council, in collaboration with Senator Curran, and also would just reiterate, as was shared, in order for this to be effective, it does relate to other sections of statute that also need to be addressed, and so I want to be sure that we do it right and take our time to get the language right, and so that is in process, and so would ask that we continue that work that is happening and not adopt this amendment today.
Mr. Chairman.
Senator Limmer.
Thank you, Mr. Chairman. Senator Boldon, could you tell me what other areas of law that this would affect?
Senator Boldon.
Thank you, Mr. Chair. Thank you, Senator Limmer. I do not have that in front of me. I'm happy to get back to you with that, or perhaps someone can work on that while we're in committee here, but I don't have that in front of me at this time.
Mr. Chairman,
Senator Limmer.
if this amendment would pass, I would then alter the final motion and send the bill back to elections for their scrutiny and to possibly add these other elements to it. So, Mr. Chair, I'll stand with the amendment before us and ask for a roll call vote.
So there's been a request for a roll call, so when we have a vote, there will be a roll call on it. I'm pretty concerned about jurisdiction here, but I also, having heard the chief author indicate that she is working to accomplish the purposes in this amendment, but through a bill that's in Elections Committee, which is the proper committee for a substantive change of this nature. Certainly it would be the Committee of Original Jurisdiction for a substantive change of this nature. And so if Senator Limmer intends for us to proceed with a vote, I'm going to be voting no for that reason. Senator Curran.
Thank you, Mr. Chair. I mean, we just went through a 5-page amendment that was squarely within the purview of the Elections Committee, except for one minor part on an amendment that I was just looking through right before the, committee, and basically taking other people's words that it was non-substantive. So I think we should get some leeway on this amendment from a jurisdictional standpoint. So I appreciate that. We'll be having a vote on this. I would just echo Senator Limmer's comments that if there is another subdivision that needs to be amended, that could be done by the Elections Committee when this bill goes back to them, and they can take a look at that. But in the fact that the author is working with Senate Council, apparently, that it still hasn't passed. And so, and we're looking at the bill that's in front of us, and it's a good amendment. And if we all agree on it, we should pass it. Thank you.
Well, Senator Curran, I've indicated, and I've indicated this in other committee hearings as well, so I'm not changing my position on this. If something comes to us that isn't squarely within our jurisdiction, but there's the chair that does have jurisdiction is fine with us addressing it, and that it does not appear to be very substantive, and there does not appear to be any stakeholder conflict over it, then I'm going to treat it basically as an update to the bill rather than a major policy decision by this committee. So that's why I was okay with addressing the A60 amendment in this committee. Senator Limmer's A61 committee is an entirely different kind of bill. It makes a substantial policy change to our election laws. And that's just, frankly, not within this committee's jurisdiction, certainly not as original jurisdiction. Maybe one could make an argument because of civil penalties that it could be, but the practice of this committee, at least this session, has been if there are substantive changes to the law, but there aren't any significant changes to civil penalty provisions themselves, those changes are to be made by the Committee of Jurisdiction on the policy, and we're just frankly passing on bringing every bill that has a fairly minor civil penalty adjustment or implication to this committee, or we'd all be here every night until midnight. So it's one of those borderline questions. We've had conversations with counsel over those questions. So with all due respect, Senator Kroon, I disagree with your conclusion. But I will state for the record, and I know you've asked, there's been a request for a roll call, and it's clearly a desire to get members on the record with regard to this particular policy change that belongs, in my judgment, in the Elections Committee. I also have no doubt this is going to be subject of a floor discussion at some point, too. But I will state that I agree with the goal of the A61 amendment, however it's done from a process standpoint. So on the merits, I would likely be voting for it, but I'm not viewing this as a vote on the merits. You can use my vote, I guess, however you want sometime down the road. Senator Kroon.
Mr. Chair, just a question on the process here. So it sounds like there's some additional work being done, and there's another subdivision that needs to be addressed similarly. That's what I understand the conversation to be, and that the chief author is working in a bipartisan manner to address this. But I also understand that this bill isn't going back to the Elections Committee. And so if this were going back to the Elections Committee for these amendments to be made in the Elections Committee, then I could see that, but it sounds like it would just be going, explain this, is it just going into an omnibus bill without an actual amendment to include this, or what's happening here?
Senator Kroon, my understanding is it goes to finance from here, but Senator Boldon, is that correct?
That's correct, Mr. Chair. Senate File 3 will go on to finance. The work that I'm doing in collaboration with Senate Counsel and Senator Curran around the policy in this amendment is actually connected to a different bill, which is sitting in the Elections Committee right now.
So, for what it's worth, Senator Limmer is on the Finance Committee as well. And so is Senator Eichhorn from this committee. Senator Kroon, follow up.
Thank you, Mr. Chair. Well, I mean, we're dealing with this bill, and if this bill were going back to Elections Committee, I would be persuaded that perhaps the amendment to this bill should be handled in the Elections Committee, but it's not going back there. So what's happening on another bill I don't think is relevant for what we should be doing on this bill. That's my comment on that. And I also think, in addition to civil penalties on this, is there not a criminal component to this as well? Is there, maybe that's a question for Senate Counsel.
Counsel is not familiar enough with election law to be able to tell us the answer to that question, which is another reason why this really belongs in the Elections Committee. I, for one, have more faith and confidence and trust in Senator Boldon's commitment to work on this, and I have more confidence in Senator Curran's work on this effort as well in the other bill that's in front of the Elections Committee. So I'm going to, unless there's anything urgent, I'm going to bring this conversation to a close. Senator Carlson, did you want to add anything? I saw your hand go up just before we go to a vote.
Thank you, Mr. Chair. And I think your conversations have been right on. If this were a lone amendment, I would tend to support it. But the problem is that we have had an agreement with Senator Boldon, Senator Curran, to work on this to make sure that the other issues are covered as well, and that's covered in a bill that's still in Elections Committee. So if we would add this, and we would do the complete revision, that would even be further into the Elections Committee purview. So I would not support doing it only halfway.
Not seeing any further. Senator Limmer, is it still your desire to go forward with a vote on the A61 amendment?
Yes, it is, Mr. Chair.
All right, the clerk will take the roll on the A61 amendment.
Chair Latz,
No.
Senator Umu Verbatim,
No.
Senator Limmer. Yes. Senator Carlson,
No.
Senator Eichhorn,
Yes.
Senator Howe, Senator Kroon,
Yes.
Senator Pappas. Senator Seeberger, Senator Westland,
No.
Senator Howe, Senator Seeberger.
There being 3 votes in favor and 5 opposed, the amendment is not adopted. Members, is there any other discussion on Senate File 3? Senator Kroon.
Thank you, Mr. Chair. Excuse me. My line of inquiry will be on page 24, the certification provision. My concern here is that disclosure requirements for publicly traded corporations don't kick in until 5%. And so the definitions here, which could revert back to a foreign influence corporation, which reverts back to page 22, says that the threshold is 1% for an individual owner in a corporation for it to be considered foreign influenced. And so I guess my question is, if a publicly traded corporation isn't going to know who all of their investors are, and the ownership of a publicly traded corporation changes daily or hourly or by the minute. And so I guess my question is, how is this certification by the CEO or whoever on page 24, how is it possible for a publicly traded corporation to ever make this certification?
Senator Boldon.
Thank you, Mr. Chair. Thank you, Senator Kroon, for the question. And I'll just take a step back to just talk briefly about the rationale and intention of this provision. So this provision in the bill is around not having foreign influenced corporations be able to spend money in our elections. We know that, that is something Minnesotans want us to take action on. It should be Minnesotans having voices in our elections, not foreign influenced corporations. So that's the intention of this provision. And it is set at a threshold of 1% if it's an individual and 5% if it's 2 or more folks. That's the threshold at which has to be certified, as you said. I will say if, you talked about the makeup of that, or the shareholders may be changing from minute to minute or day to day. This language requires that it would be taken on the day that the contribution was provided. So they know what their, the makeup of their shareholders are on a given day. It would be the day at the time of the contribution. And if they, are wanting to spend money in an election, they will need to know the percentage of foreign influence. I will also just note here that we're not talking about control over a corporation. We're talking about influence over a corporation. So those thresholds were set intentionally, as that's what has been sort of noted and documented at the levels where there is influence in a corporation. I will also maybe note, Mr. Chair, we do have Mr. Fine as an expert in this area is on Zoom, who may be able to speak in more detail around this as well.
Mr. Fine, are you with us on Zoom?
Yes, Mr. Chairman.
If you'd like to go ahead and identify yourself and your affiliation, and if you have anything to add to answer this question, I'd appreciate it.
Yeah, my name is Ron Fine. I'm the legal director of Free Speech for People, which is a national nonprofit, nonpartisan organization. And I submitted extensive written testimony to the Judiciary Committee addressing this and other points, including as an attachment a letter in support of a nearly identical bill in another state that was submitted by Professor John Coates at Harvard Law School, who's a corporate governance expert and a former general counsel of the Securities and Exchange Commission. And I would say two answers in response to this. First, as a formal matter, it is true that from second to second, publicly traded corporations don't know who owns every single share, but they definitely can find out as of any particular date. It's called a record date. They do this on a regular basis. For example, whenever they have their annual meeting, they have to do that. They have to find out every single shareholder. And they also do that at certain other corporate occasions, for example, related to a tender offer. As a practical matter, if you were to ask the CEO of a, say, Fortune 500 company, off the top of your head, can you name every shareholder that owns at least 1% of your stock? I'll bet you they could. And the reason is that a 1% investor, that's hundreds of millions of dollars. These are the people who can make the CEO's life miserable if they want. They can, make a push to get him ousted. They can, will have his cell phone number and he'll take their calls. So it's actually only going to be a handful of investors for a major company that rise to that level. Most publicly traded companies, maybe they have 5, investors at the 1% level. So it's not going to be obscure information. But again, to get it at an actual determinative level, they can go through the same procedure that they do on a regular basis, at least once a year for their annual meeting to determine that the shareholders as of a record date.
Thank you, Mr. Fine. Any follow-up questions for Mr. Fine or Senator Kroon?
Thank you, Mr. Chair. Well, despite the record date and the assurance that I'm sure they would know, we're making law here, and you're asking a CEO to certify something with some rather stiff penalties associated with an improper certification. And publicly traded companies are not just Fortune 500 companies either. And the reality is, with compliance departments and the stiff penalties associated with this, it would be very, very difficult, if not impossible, for a CEO of a company to certify with these provisions that they are not a quote-unquote foreign influenced corporation under the definitions of this bill, without some concrete assurances based on disclosure requirements. It's not just, I bet they know, or they should know, or they probably know, and in most cases they know. That just isn't going to cut it. And so the way I look at it, and maybe I'll just phrase this as a question to the chief author, is the intent of this bill to ban all participation from all publicly traded corporations?
Mr. Fine or Senator Boldon?
Mr. Chair.
Senator Boldon.
Thank you, Mr. Chair. Thank you for the question. It is, I would argue that perhaps Minnesotans might like that to be the case. However, that is not the intent of this bill. The intent of this bill is to eliminate influence of foreign dollars in our elections. And I would just add respectfully, Senator Kroon, I sort of disagree with your premise that we're asking something that maybe they know, maybe they don't. This is a process, the record date process to know who their shareholders are is a process that exists that they are already using. So we're not asking them to do something that they cannot do. They can do this, and they should do it if they are wanting to spend money in our elections.
Senator Kroon.
Thank you, Mr. Chair. And I don't believe the record date that was referenced would give a comprehensive list of every single shareholder in a corporation. And so I don't think that there is a reasonable, practical way for complying with this. And whether or not Minnesotans agree or disagree with this concept, there are constitutionality concerns here. I mean, you may not like Citizens United, but it is the law of the land. And so it seems to me we are effectively prohibiting those corporations from engaging in this in their constitutionally protected right through a statutory scheme that makes it virtually impossible for them to comply with. I also have concerns over federal preemption here. I mean, federal law already regulates and restricts foreign influence under federal law. And I would assume that one of the primary reasons that Congress gets into that is it's within the purview of Congress to set foreign policy and regulation of foreign spending in our elections. And so my concern here is why do we think it's within the purview of the state of Minnesota to make those, I guess, foreign policy decisions here through our state election laws?
Senator Boldon.
Thank you, Mr. Chair. So you're correct that under federal established law, upheld by the Supreme Court, it is illegal for a foreign government, business, or individual to spend any amount of money into all federal, state, or local elections. However, that federal law leaves a gap that has been further opened since Citizens United, as you referenced. So the existing federal statute prohibits a foreign registered corporation from spending money on federal, state, or local elections. However, federal law does not address the issue of political spending by U.S. corporations that are partially owned by foreign investors. So there's a bit of a loophole or a gap here that we're trying to address. And you know, I think we need to just take a step back here and talk about, just remember what we're talking about here. We're talking about foreign influence in our elections. And so, you know, that is something we should take seriously. Foreign companies don't have constitutional free speech rights related to our elections.
Senator Kroon.
Mr. Chair. Yeah, I was trying to keep this squarely within, you know, the jurisdiction of the Judiciary Committee, and
Much appreciated, Senator Kroon.
but your response compels me to, I mean, it's, foreign influence sounds sinister, right? But the way that this bill is drafted, somebody with less, you know, with a 1% stake, I mean, that's a real judgment call on how much influence that shareholder can assert over the corporation. And given our modern world with our global markets and how our corporations function in reality, this stifles it to the point of excluding them from the process. Now, I'll try to get back to the judiciary aspect of this. I would say that, and I thank you for your response here, but just because Congress does not address something doesn't necessarily make it a gap or a loophole. It could be a conscious decision as well. So I do have concerns over preemption on this issue as well, and whether or not we are preempting federal law by trying to address this foreign policy decision through state law.
Senator Cronin, is there a question there for Senator Boldon, or you?
No, that was just a comment. Thank you, Mr. Chair.
I have a question for Counsel Primo relating, well, two questions relating to Article 2, Section 2, the intimidation provisions. On line 19.21, there's a civil action provision relating to the intimidation prohibition, and it's worded, for me anyway, a little unusually, and so I'm trying to get a sense of what the implications are. On line 19.23, it uses the words "may show." So the sentence says that a civil action brought to prevent and restrain violations of this subdivision or to require the payment of civil penalties, the moving party may show that the action or attempted action would cause a reasonable person to feel intimidated, and goes on to say they don't need to show the actor intended to cause that that outcome. So it's basically that they caused the act, which is not an unusual provision, but what is unusual, in my observation anyway, is the may show language. Ms. Primo, can you help me understand the implication of using the language there? I mean, I don't know if we need to give the court permission to accept evidence relating to, what the plaintiff is attempting to show. Ms. Primo?
Mr. Chair and members, I think perhaps the intent of that language is to create a specific standard that the petitioner must demonstrate. So it makes sense to at least, if that's the intent, to delete may and insert must, and instead of show, you could use demonstrate. So must demonstrate that the, or must show by a preponderance of evidence. Sometimes it's tied to that sort of language, but at least the may to the must makes, might be appropriate here.
Senator Boldon, what are your thoughts on this question?
Thank you, Mr. Chair. So I would say this, it's an element of the civil portion, so we are attempting to create a reasonable person clause here, or the intention that counsel referenced is correct.
So the intention, Senator Boldon, is for this to be a standard civil burden of proof, preponderance of the evidence, right?
Yes, Mr.
Senator
Chair.
Boldon? Okay. And we don't need to specify that in statute because that is the default civil standard if we say nothing. But I think we probably are better off indicating, replacing may show with a must demonstrate. So the element of the civil liability is clear in statute. Ms. Primo, is that what you would recommend for clarification on this provision?
Mr. Chair and members, yes.
Senator Westland, would you be willing to make a motion then on line 19.23 to delete the words may show and in their place insert must demonstrate?
Yes, Mr. Chair, I would like to make that motion.
Senator Boldon, you support that amendment?
I would, Mr. Chair.
Members of the committee, any discussion on that proposed amendment? I'm not seeing any on Senator Westland's motion to amend line 19.23. All those in favor say aye. Aye. Opposed? The motion prevails. The amendment is adopted. And then, Ms. Primo, I had another question for you, if I may, on page 20, subdivision 5, paragraph B, starting on line 20.15. It does provide for a civil remedy which includes injunctive relief identified in paragraph B. And the part I'm inquiring about is the line 20.17 language that would authorize a court to prevent or restrain a violation if there's a reasonable basis to believe that an individual or entity intends to commit a prohibited act. And that sounds to me kind of like prior restraint, and I'm not sure what to do with that. So I'm wondering if council has some input on that question. Ms. Primo.
Mr. Chair and members, the restraint on a prospective or a potential violation that has not necessarily been committed or is in the course of being committed could pose potential issues. I'm not necessarily sure how to get around that potential free speech issue and still maintain the intent of the language. I would, maybe need to look at case law and consult with maybe some experts on that piece. I just don't know how you mesh the two together.
I mean, Ms. Primo, I'm a little more familiar with, New York Times versus Sullivan and the prior restraint application directly to free speech. And, a court can't tell a media organization that you cannot publish this news or information. However, if they do publish the information and it violates some law, then they can be held responsible or liable, and they could be, have to pay damages for it. And this is sort of a prior restraint on what might be speech or other conduct. And I think the same principle would apply, but that's one of my questions. Maybe some of the lawyers on the committee who have a recollection of prior restraint law from law school, if you don't practice in it, might be a little far behind us. But Senator Westland, Senator Crewen, Senator Westland, I think I got a note here you wanted to comment.
Thank you, Mr. Chair, and it's been a long time since I've had con law, a really long time. But I don't, so in my opinion, with that caveat, there isn't prior restraint of speech. There isn't a censorship issue. This is dealing specifically with a person engaging in intimidation and interference with an election. And we do know that if we become aware of situations, certainly restraining orders are often issued to prevent people from acting, either harassment, domestic abuse restraining orders. You could probably speak better to the criminal law, but I think that if a conspiracy is identified, even though it has not been fully completed, law enforcement can still intervene. This is not an attempt to restrict speech. It is an attempt to restrict behavior that is unlawful, and specifically the practices outlined and defined in subdivision 1. They can't threaten, force, coerce, engage in violence, and so forth. So I don't think this is a speech issue. I think this is an issue that if a plan to engage in those activities is known, that a person can obtain injunctive relief and can pursue judicial intervention to prevent that those actions from taking place. Again, long time since I've had con law, but I don't think we're talking about speech here. I think we're talking about restrictions on unlawful behavior.
Senator Boldon, any thoughts on the question here? I
yeah,
understand
thank
it
you.
may have come up in election committee as well.
Thank you, Mr. Chair. A couple of thoughts, and then I may turn to another expert online if that is appropriate. A couple of things I would say is, intimidation of voters isn't constitutionally protected speech. However, much of what we're addressing in this provision, as was stated, isn't related actually to speech but behaviors. The other thing I'll note is that this language is from the enabling statute for the AG to seek injunctions. And so if I could, I would also invite Mr. Danjuma online to speak to this as well.
Good morning, members. Can you hear me?
Yes, go ahead and state your name. Would you spell your name out for me so I can pronounce it
Certainly.
correctly?
My name's Orion Danjuma. That's Orion. The last name is Danjuma, Danjuma.
Thank
And
you, sir.
I'm counsel with Protect Democracy.
Thank you. Can you shed some light on this? I might be
Certainly,
completely off base. I'm
certainly,
asking
members
the question.
and chair. So we studied some other enabling statutes in Minnesota, and we believe the language prevent or restrain comes specifically from subsection 8.31 subdivision D3, specifying the duties of the Attorney General, which uses the same language that the Attorney General can seek injunctive relief to prevent and restrain violations of those laws. And what I see as sort of importing that provision into this subsection is to just provide the same ability for the Attorney General or a third party to seek an injunction from a court to stop voter intimidation. That's what this is intended to prevent. Prior restraint is a term of art that specifically applies to First Amendment circumstances. So there are some circumstances where a voter intimidation incident could involve some form of protected speech, but many, and indeed most of them, do not. And a court would properly apply the federal constitutional standards for a case that would involve speech. But if, for instance, a group of individuals, the Attorney General learned that a group of individuals planned to attack a voting location, no speech was involved, and they intended to do that, the Attorney General could seek an injunction preventing that. That is the idea, and that would not involve speech at all in that example. Does that make sense? Does that help?
That does help me, and of course, any such questions that might come up would ultimately get sorted out by a court that was considering the motion to enjoin the conduct that is feared would take place. Ms. Primo.
Mr. Chair and members, I did look at the AG statute, and it does use the language prevent or restraint, which is perhaps not the real issue here, but this is more so getting at the line that you had initially pointed out. For the committee's consideration, whether it makes sense to not include the phrase, if there is a reasonable basis to believe that an individual or entity is committing or intends to commit a prohibited act, because the substantive provisions of this section already provide the specific standards that result in the violation or that would need to be proven in court. So you could just say the Attorney General or any person injured by this act, prohibited by this section, may bring a civil action to prevent or restrain a violation of this section, period. Because in some ways now you have the standards in the substantive portions plus a standard of a reasonable belief. And it's purely from a drafting perspective. and like a statutory interpretation perspective, whether that is maybe unnecessarily confusing for the committee and experts' consideration here.
Mr. Danjuma, do you have an opinion on what Ms. Primo suggested as an approach here, which is on line 20.16, put a period after the word section and delete the rest of that?
Yes, I'm checking that now. I guess, and I'm interested to hear what Ms. Primo feels about this, but the issue may be that attempts still would be precluded. There may be some question about whether or not about the scope of a violation. So I see this language as not problematic, but also encompassing sort of an intention before the violation is committed, but if there is a clear intent to commit a violation, and I'm not sure if that would be covered if that language was removed. But I'm checking to see if it might be encompassed already.
While you're doing that, Mr. Danjuma, we'll see if there are any other members of the committee have questions about this. I mean, I'm going back and rereading the substantive provisions in section 2 here. And line 19.13, it talks about no person using or threatening. But those are specific acts which have already begun. And certainly if there were preparatory steps taken toward voter intimidation, those are acts. But I would think theoretically anyway, line 20.17, intends to commit, could be entirely a function of what's in a person's mind without any affirmative acts taken in that direction. Senator Westland?
Mr. Chair, just the lines 19.21 and 22, actually, this is part of the section we just amended earlier. It actually says, notwithstanding paragraph A, in a civil action brought to prevent and restrain violations. So that paragraph does incorporate the notion of restraining, potentially restraining individuals from committing the acts. And so I do wonder, I do wonder if the additional language in 20.16 and 17, I'm kind of wondering if that is necessary, but again, maybe Ms. Primo can help us sort out whether this gets, it seems to me that it gets to intent. Oh, actually, sorry, subdivision A2 19.18 does say any person with intent. So I am wondering if removing 2.16, if there is a reasonable basis, and deleting the rest of that could be removed because it's already contained in the definition provisions of subdivision 1.
So, Senator Westland, I'm less concerned with the language that authorizes a restraint, and more concerned with the language that simply says intends. If we go back to line 19.23 in the civil action provision in subdivision 1, the showing would be that the action or attempted action. So you're dealing directly with conduct, and an attempt has already begun. But it doesn't say intended action.
Mr. Chair, but if you go up to
Senator Westland.
I'm sorry, Mr. Chair.
No, I'm just.
Subdivision 1A2 does say any person with intent. to impede efforts to encourage another to cast a ballot. Like, that's part of, there is an intent, and subdivision 1, both have intent embedded in the definition. Intent to,
Correct, Senator Westland, but that intent refers back to the use or threatened use of force, et cetera, in paragraph A, at the opening line on line 19.13. So it's an intent tied directly to action. Okay, so we're getting deep into statutory analysis and constitutional questions here. But I guess I'm inclined to solve this in the manner in which Ms. Primo is suggesting, because I'm not sure that the language that goes on to if there is a reasonable basis to believe an entity is committing or intends is necessary to effect the purpose of this provision, which is, I think, to give the Attorney General the authority, or any person injured, give them the statutory authority to seek an injunction. Senator Limmer.
Mr. Chairman, to encourage a full discussion, there might be another individual on our Zoom connection that may want to contribute to this discussion.
I'd love to hear it. Who are you referring to?
Mr. Bradley Smith. I was told that he is on the line.
Mr. Smith is appearing on our
video to
screens.
show up.
Thank you, Mr. Smith. Go ahead and
Thank you.
identify yourself and your affiliation and tell us what you have to contribute.
My name is Bradley Smith. I'm currently a professor at Capital University Law School. Previously, I served 5 years on the Federal Election Commission after having been appointed by President Clinton in 2000. And I'm also chairman of the Institute for Free Speech based in Washington, D.C. I was here today mainly to talk about some of the provisions that more directly regulate the political speech aspects, campaign finance, some of the things that you've already talked about, such as the idea of foreign-owned corporations, which include, such American icons as Burger King and Jeep and so on. As to the issue of voter intimidation, I do think one always has to be careful. One of the things that the Supreme Court has made very clear is that you can't limit someone's speech based on the subjective hearing of the person hearing it. So typically voter intimidation statutes and prosecutions are connected to some type of action that actually is a physical intimidation or a direct threat at somebody's participation in the election. But again, my primary focus, I will say, has been on more direct aspects of efforts to regulate political speech in the arena.
Mr. Smith, thank you. And to me, that sort of affirms the direction I'm tending to go here, which would be to eliminate the language that appears mainly to restate the grounds for, an enforcement action that's already identified earlier in the subdivision, but may stray into getting into people's thoughts that have not translated to action yet. And I'll note there was a reference earlier to the orders for protection and DANCOs and stuff like that, but there has to be a demonstrated showing for a court to grant those that there is a reasonable basis for the person to fear harm, and that's done typically with prior acts. This person has taken steps, has done things in the past to make me afraid that he or she is going to do it again, so I want a court to say, no, you can't, and here are the consequences. But it's a difficult line to draw.
Mr. Chair,
Senator
I'd be happy to make a motion to amend line 20.16 to place a period after the word section and to delete the remainder of the line, delete all of line 20.17 and 20.18, and would ask the author, I guess, if that would be considered a friendly amendment.
Senator Boldon, what are your thoughts on that?
I would be okay with that amendment, Mr. Chair. Thank you, Senator Westland.
I think I'm going to try to channel Ms. Primo here. I think she would characterize the amendment as after, on line 20.16, after the word section, delete the rest of the line, delete all of line 17, and delete line 18 up to the period. No, because the period at the end of the sentence remains in place. At the end of line 18, that period stays, and we're just deleting the text before that. All right, I did it wrong last time too, and Ms. Primo corrected me, so I think I caught that now. All right. On Senator Westland's amendment to that effect, all those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Is there any further discussion on Senate File 3? Senator Cruen.
Thank you, Mr. Chair. In light of Mr. Smith on the line, I kind of wanted to revisit my previous line of question, but in another concern came to me as I was sitting here. We were told that it would be easy for a CEO to know who, if there's any foreign citizens that own 1% of a publicly held corporation, because they would just know that. But then I started thinking, but even if that were the case, which I don't think it is, there's still a problem of the aggregate of 5%, because that could be a number of individuals who own less than 1% that they wouldn't know about, but in the aggregate could add up to 5%. And so my concern about the possibility of the CEO certifying this remains on that front too. I guess I was just wondering if Mr. Smith could chime in on either of those issues, the 1% individual or the 5% aggregate requirement.
Yes, well, thank you. Obviously, in a modern economy, there's a great deal of foreign ownership. And what I would point out more generally are two things. First, when we talk about foreign influence corporations with as little as 5% or even 1% foreign ownership, remember that we're typically talking about the interest of U.S. citizens. For example, Jeep Corporation, generally considered the most iconic American brand, would be precluded under that regulation. Burger King, great American company, employs over 30,000 people in the United States, headquartered in Atlanta, would be precluded under that provision. Why should it be that the employees of these companies and the shareholders, the American shareholders who make up the vast majority of the people you're talking about, would not be allowed to participate? And Anheuser-Busch, Budweiser would be out. And these are, so you're really affecting Americans much more than foreigners. But more importantly, it's an issue of constitutional law. Then remember, the Supreme Court has never suggested that you can blanketly limit the speech of foreigners in the United States. People who are in the United States have a right to speak. Lawful permanent residents, there's nothing that says simply because somebody is not from the United States, they cannot speak to United States citizens. So I do think the provision is probably unworkable, you're taking an approach that would be very difficult for, I think, companies to live with, and would have the effect of limiting the participation of Americans in the discussion and the representation of Americans, those employees who need the corporation to speak as to what is good for the corporation and thus good for their jobs and benefits and so on.
So, members, I'm going to just ask a question. We do have a witness that has to leave at 11 for the bill that's next on the agenda. I'm not trying to cut this discussion off, but if there's going to be some extensive further discussion on this question, I'm going to lay the bill on the table until we complete the next one and then come back to this. So let me just ask if there's a sense of where members are going on this, and Senator Cruen in particular, who's inquiring about this particular section. Do you think you're about, I guess the question is, do you think you're about done and we can get to a vote on the whole bill? Or if you're not, that's fine. We'll just have to come back to it in about 15 or 20 minutes.
Thank you, Mr. Chair. I was about to wrap it up anyway, so however you want to handle.
If you can be done in the next minute or two, Senator Croon, that's fine. You can wrap it up, and then we will proceed to a vote. Senator Croon.
Thank you, Mr. Chair. Yeah, I guess my comments would be, Mr. Smith touched on some things. I was focusing on the workability of it and the practicality of it. And my concern with both the 1% individual and 5% aggregate limitations is that it would effectively have a chilling effect on the corporation because it's under penalty of perjury with substantial penalties, that essentially what we're doing here is shutting out all publicly held corporations, in my view, which have serious constitutional implications, in my view, as well. And I would add not just publicly traded corporations. This could bring in privately held corporations possibly too, if maybe they would know who their shareholders are, but you could still have a situation where, you've got an uncle who lives in Canada with 1% stake in a corporation, and then this bill would shut that Minnesota corporation, let's say, out from having any kind of say. And again, we're talking about issue advocacy. We're not even talking about direct contributions to candidates or campaigns, which is already illegal. But Mr. Smith brought up some good points beyond that about who we're actually talking about and what the reasons they may want to participate in this process. So I just think that it's unworkable as drafted and would effectively ban all publicly traded corporations. I think there are constitutional issues. And so for those reasons, I don't think we should move this forward. Thank you.
Is there any further discussion on Senate File 3 as amended? Not seeing any, Senator Carlson moves that Senate File 3 as amended be recommended to pass and be re-referred to the Senate Committee on Finance.
Mr. Chair,
Senator Croon.
I would like to amend the motion to send this back to Elections Committee for reasons I stated at the beginning of this conversation related to the amendment.
Senator Croon moves to amend the motion to re-refer this Senate File 3 to the Elections Committee. All those in favor of Senator Croon's motion, say aye. Aye. All those
yes.
Opposed? No. Motion does not prevail. On Senator Carlson's motion to recommend that Senate File number 3 be recommended to pass and be re-referred to the Senate Finance Committee. All those in favor say aye. Aye. Opposed? No. The motion prevails. Thank you, Senator Boldon.
Thank you, Mr. Chair and committee members.
Next on the agenda, Senator Pappas, Senate File 2798. Senator Pappas.
Thank you, Mr. Chairman. I'm here before the committee with Senate File 2798. I'm happy to assist our sister city to the west, and I have with me Chief O'Hara, and he's going to testify as to the need for this change.
Senator Pappas, before we have that, there is an A1 amendment in the members' packets. It's an author's amendment. Senator Pappas moves adoption of the A1 amendment. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. The amendment's adopted. Chief O'Hara, welcome to the committee.
Thank you, Chair.
Why don't you go ahead and explain what it is you're attempting to accomplish here?
Good morning, Chair. Thank you, Senator. Thank you for having me. So this is about a statute that limits the amount of deputy police chiefs the Minneapolis Police Department is allowed to have. It only applies to the Minneapolis Police Department, and the statute is from 1961. And as best we can tell, we are unaware of why the statute was enacted in the first place. And clearly, we have significant issues that we are trying to address in the city, particularly around crime and the number of crime victims in the city, but also issues around accountability and rebuilding trust in the police department. So I come to Minneapolis, having started as a police chief in November after spending 22 years in Newark, New Jersey, 5 years of which I led reform efforts under a federal consent decree. And we had significant progress at advancing reforms under the consent decree, but also significant progress around addressing issues of serious street crime and gun violence. So I come here today with that perspective as an outsider in Minneapolis, and I am aware of what the police department will have to do going forward to enact meaningful reforms, but also what we have to do to ensure that we have real accountability and we're able to address with urgency the very real problems that people are having in our city around serious street crime. Over the last few years, I'm sure it's no surprise to anyone here, we have experienced the highest rate of gun violence in a generation in our city. At the same time, the police department has been struggling to rebuild. And I think eliminating this statute will enable me to enact the structure that is required to ensure that we are able to respond and address with urgency the challenges that we are facing around serious street crime and violence. And just so that folks here are aware, the only real similarity we have today with 1961 is we have about the same number of sworn police officers. Everything else is dramatically different. In the state of Minnesota in 1961, there were 36 homicides, compared with over 200 in recent years here. And 94 of the murders last year were in Minneapolis. So our cops are working incredibly hard. As I sit here right now, they are on a scene arresting a very violent offender wanted in connection with gun violence and have just recovered a handgun. But we need to enact the support at a higher level to have a greater command presence to ensure that we are able to address with urgency the very basic mission of our agency. This is about giving me the ability to bring this police department back to basics. We have to structure this agency so that we are working every day with urgency to have fewer victims of serious crime and violence, and also to rebuild public trust. So as we do that, year to date in the city, despite even having 35 fewer cops than at this time last year, we have already recovered 117 illegal guns, which is 35 more than last year. We've already had over 30 fewer victims of shooting incidents in the city, and we have fewer murders at this point this year than we did last year. So I think it's obvious that our cops are working incredibly hard, but we need to be able to structure the agency so that it has a true hierarchy. If you look at the numbers today in the police department, even with fewer staffing, the bulk of the agency is at the bottom, police officers and sergeants. And instead of having a more stratified chain of command presence, it's a very narrow number of personnel in ranks as it goes up from commander and inspector to deputy chief. So if this statute is eliminated, this will give me the ability to focus on operational issues, but then break off and have a deputy chief that would ultimately be responsible to implement a consent decree, which we know is coming. And from my experience and what I know, this is actually something that's required under these agreements. If you look at any of the recent consent decrees, whether it be Newark, New Orleans, Baltimore, or others, a part of those consent decrees are that there be a high-ranking police official that answers directly to the police chief that's responsible for implementation of these agreements. So that's one thing. The other thing that I plan on doing with this is ensuring that we have a deputy chief who oversees internal affairs processes. Clearly, I know our police officers are unhappy with the way the disciplinary process works, as well as our community. So being able to create 2 additional deputy chiefs positions will allow me to do this, and quite frankly, it will give us, it will actually bring us a little bit closer to the way the fire department in Minneapolis is structured. The fire department has 7 deputy chiefs right now. However, the police department is limited to 3. So I'm thankful to the chair and the senators for considering this amendment to allow us to improve the agency. Thank you.
Thank you, Mr. Chairman. It just seems odd to me that the legislature should be so prescriptive in how a city wants to run their, in this case, police department. And I'm not even sure why we have this chapter, 1961, 1969, 1978. It goes back really far. But at this point, I think if we, I mean, that would be up to kind of the Minneapolis legislators if they wanted to delete this whole section of law. But in this case, let's at least make this reform.
Well, Senator Pappas, I understand if we eliminate the statutory restrictions here, then the city of Minneapolis, through their city council, would have the legal authority to amend their charter to affect the same flexibility.
Maybe that's a very
for the
arduous
agency.
process.
Is that right? I think that's what's incorporated into the effective date language. Is Senator Limmer.
Thank you, Mr. Chairman. A couple quick questions. First, Chief, do you have the blessing of the City Council and Mayor regarding this change?
Thank you, Chair. Thank you, Senator.
Chief O'Hara.
Thank you, Chair. Thank you, Senator. This change must go forward first before I can propose the 2 new positions I would want to the City Council. So yesterday there was a vote on a related change, 2 other positions for the police department, and that vote passed. I had also presented to them in this process the 2 specific deputy chiefs positions, and they seemed receptive to that. However, I cannot present those 2 positions unless the law is actually passed. But it was part of a plan that I presented to the City Council on Tuesday, and they voted for 2 of the positions, 2 of the 4 positions yesterday, and it was approved.
So, Mr. Chairman,
Senator Limmer.
Chief, you have, for lack of a better description, a partial approval of a hypothetical corporate structure.
Chief O'Hara.
Thank you, Chair. Thank you, Senator. Yes, I was proposing 4 new positions, 3 of which would be sworn, 1 of which is a civilian, as part of the vision for how the executive structure should be functioned. And they were able to approve 1 sworn position and 1 civilian position. They are aware of the other 2 as part of the vision. Yes.
Right. And, Mr. Chair,
Senator Limmer.
in this plan to widen the command structure in the organization, is this to preclude with an idea that the Minneapolis City Council and Mayor would support more cops on the street? We hear many concerns that they do not have enough police officers, and with the widening of the command structure, I would hope that that is a precursor to widening the patrol presence with more numbers in the police officer complement. Can you give us any information on that?
Chief O'Hara.
Thank you, Chair. Thank you, Senator. Yes. We have in the budget hundreds of vacant positions right now, and clearly we need more police officers. It is amazing to me the incredible work that is being done by the cops who work there now. I can't say enough good things about it. They are all doing multiple functions in the department, and it is absolutely incredible the work that is being done. And I think everyone here could recognize the importance of that issue of having, not just having more officers, but having good police. Having police that are hardworking, doing the job right, and making a difference, because, you know, quite frankly, I'm sure we all know the crime does not stop at our borders, right? And so the way Minneapolis goes will affect the entire region and really the crime statistics for the entire state. So yes, part of what is happening right now, and what I try to do personally every day is to be present and to try and change the narrative internally and in the community with the police department. And what we are starting to see is we are starting to see an increase, on some level, an increase in applications and an increase in interest in becoming a Minneapolis police officer. I was in Newark 3 years ago, in 2020, and I can tell you these blue shirts, this police department was on my TV every day, just like it was on everybody's TV around the world. And so we have a huge issue around perception about who we are as people, who we are as cops in Minneapolis. And we've been working very deliberately to try and change the narrative around that, because until we start winning that battle, we won't be able to get the numbers that we need. But yes, it is absolutely critical that we get more cops. And these two positions wouldn't be taking two cops off the street. These would be two administrators that would be moved to a different assignment. And quite frankly, it would help us communicate internally what we believe is important to be doing as a police department.
Any further discussion? Senator Verbatim.
Thank you, Mr. Chair. Thank you, Chief O'Hara, for being here. You mentioned the narrative that needs to be overcome, but you also mentioned the consent decree, which, of course, is in reference to the Department of Human Rights finding a pattern of racial discrimination in the Minneapolis Police Department. And from your testimony, it's my understanding that you're looking to use some of these deputy chiefs of police positions to comply with that consent decree and to make some necessary changes. So can you speak more about how that's going to enable you to do that and end a pattern of racial discrimination in the Minneapolis Police Department?
Yes.
Chief O'Hara.
Thank you, Chair. Thank you, Senator. So my experience up until this point has been around federal consent decrees, handling one and implementing one myself, as well as, engaging with other colleagues around the country, and there's not many of us who have been through this before. So the city right now is preparing to get into a settlement agreement with the state, but we're also actually under federal investigation right now, and ultimately we'll have a federal consent decree, I believe, as well. So having been through this before, I know what this looks like. I know what is needed. I know what is actually required. I know what is going to be required by the state. That's confidential now as part of the negotiations. But I know what consent decrees require as well. So despite having a federal or state mandate to do this, we need to make these reforms anyway. So being able to do that requires me to have a command structure that ensures that we are communicating both internally in the department and to the community what we think is important. So being able to have a deputy chief overseeing constitutional policing, whether or not we have a consent decree or not, shows that we believe that's on the highest level of stuff we need to be concerned about. And we need to have civilian staff and other support below that to ensure that we are doing the work to collect the data accurately, to see what are we actually doing in terms of our policies and practices, what does the community think about us, and what gaps are there that we need to try and address. A lot of this stuff will involve changing policies and then actually being able to measure implementation and to do so in a meaningful way that involves engaging with community. So that implementing any of this stuff is really a gargantuan task that could last for years, but it's something that we need to do regardless of some court telling us we have to do it, period. And on the other end, I've seen how the internal affairs process plays out here, and I know there's lots of stuff we could talk about around that to ensure discipline could be more effective, but I believe, again, having a deputy chief that only oversees internal affairs instead of internal affairs being buried in another bureau with all sorts of other things around it is important to ensure that we are focusing attention on what matters the most, to ensure that we can, try to have a system that both our police officers and our community will view as legitimate. And I don't think we're in that space right now. I think a lot of folks, I think a lot of cops, I think a lot of our residents are frustrated about it. And it's not something that needs to be, you don't need to have the death penalty for every offense that somebody does, right? So I just think we need to have a better structure. We need to devote some more resources to internal affairs to ensure that we can conduct meaningful investigations and wind up having some level of discipline that happens close in time to bad behavior if discipline is necessary, or we're able to move faster to address whatever training or policy gaps that we see. So these two positions that I'm thinking of in the structure that I would be able to do if this legislation is passed would address both of those issues: constitutional policing and having a more effective and more legitimate internal affairs process.
Any further discussion? Senator Kroon.
Thank you, Mr. Chair. Maybe this is a question for council, but it looks like we're amending a session law. Just curious whether this is not an appropriation. It's like a policy from way back when. Why this isn't in statute and why we're amending a session law. If you could shed some light on that.
Mr. Backus.
Mr. Chair and Senator Kroon, I can try. I wasn't here in 1961 or whatever. I don't know why the legislature then didn't codify this, because it is an ongoing obligation, but it is, even though it's session law, it's still binding, so it just didn't happen to be codified.
Any other discussion? I'm not seeing any. Any members of the public present wish to participate and testify? Not seeing any indications. So members, we're going to lay this Senate file over right now so that we can have a little further conversation about where it needs to go from here. But it's deadline day, so we had to figure something out here. So at this time, we're going to lay Senate File 2798 on the table. And I appreciate, Chief, you spending the time here today. And we'll move this forward one way or the other.
Thank you.
Thank you, Chair. Thank you, Senators.
Thank you, Mr. Chairman. Is there some thought that there might be kind of a technical policy bill or something?
No, actually, there's some question about whether or not, because this affects local government, whether or not it needs to go to Chair Murphy's Committee on State and Local Government, and I have not had a chance to talk with her about that yet.
I'm rolling my eyes. All right, thank you, Mr. Chairman.
Let the record reflect. All right. Thank you. And Senator Limmer has offered himself up as a witness. All right. Members, next item on the agenda is Senate File 1900. Senator Maye Quade, come on forward.
Good morning still, Mr. Chair and members of the committee.
Okay, give us a moment, Senator Maye Quade. The packet for this bill is being distributed to our members. All right, just verifying our committee members present here in the building and remotely have been sent the packets for this bill. So Senate File 1900, Senator Maye Quade, tell us what your bill does.
Thank you, Mr. Chair, members of the committee. So Senate File 1900 is a DHS policy and technical bill. It's got a lot of things in it, but I'll actually talk about the things that are specific to the jurisdiction of this committee. Section 22 of this bill codifies the HCBS, Home and Community-Based Services Critical Incident Review Process. This currently operates as a pilot, and so the language in this statute would codify it and cement it. So what it does is it clarifies that proceedings and records of the review team are confidential data or protected non-public data in reference to opinions. It sets parameters around the admissibility of opinions and facts that may arise as part of the critical reviews, identifies the actors involved and the types of incidents reviewed, and requires recommendations to reduce the severity of and the amount of critical incidents. The other two portions that are within this committee's jurisdiction, I believe, are Section 30 and 31, excuse me. This just clarifies, currently in law, a guardian is able to establish an ABLE account for a person, but they are not able to designate then somebody who has authority over that account. So this also clarifies that they are able to designate a person to have authority over that account. Mr. Chair, I will take any questions if folks have them.
Senator Maye Quade, I'm sorry I might have missed this as I was consulting with staff, but can you tell us what an ABLE account is?
Yes, an ABLE account is an account that a person who is under care or custody, they have a custodial trustee that administers the financial parts of that account. And under current law, and still with these changes, the guardian cannot be the point person to exercise authority over that account, but they are able to set it up. And so right now they can set up accounts and then nobody can help somebody access that account.
So, Senator, are you saying there's no one who can help get access to the account right now? The account can be set up, but no one with authority to access it?
Yeah, and Ms. Grom can speak a little bit more about the details on those accounts, but yes, that's the way that the law is set up right now.
All right. Welcome to the committee. Go ahead and state your name for the record. Tell us your role here, and go ahead and proceed.
Thank you, Mr. Chair. For the record, my name is Christy Graham with the Department of Human Services. So the ABLE account is, I think it stands for Achieving a Better Life Experience. So this is a federal allowance that was passed, I want to say in 2015. So we've had these for a while. You don't have to be under guardianship to have access to an ABLE account. These are accounts for people with disabilities that essentially enable them to save money without implicating their benefits. So they can continue to work and get income and save it in this account and keep it safe there while they're able to continue to stay on medical assistance or Social Security, for example. And so we had updated guidance from the IRS on these ABLE accounts that does allow for guardians to be able to manage the accounts, but our state law limits that for people who are under guardianship. So yes, we do have situations where families and guardians have set up the account, but people don't have access to any of the funding, unfortunately.
And the guardian, him or herself, could not self-appoint themselves to have control over this account, could they?
Mr. Chair, that's
Ms.
correct. That's my understanding.
Okay. So I'm looking on page 35, members, for section 30 of the bill. Looks like there's a list of persons that could be appointed, but it does not include the guardian, him or herself. All right, and then the other provision is essentially section 22. It's a date of practices question, basically, is why it's here, right?
Correct.
Senator McEwen, okay. And then the data, the point here is that the data collected by the critical incident review team would be considered confidential or protected non-public data, and that data could not be used in civil or criminal proceedings. Is that right, Ms. Grom?
Mr. Chair, yes, that's correct. The data would be non-public or confidential, and then conversations that are had as a part of these critical incident reviews among team members would be factual information would be permissible in terms of evidence for a criminal or civil matter, but opinions would not be permissible.
and hence it would enable the free flow of conversation and opinion sharing within the team.
Yes, and
That's the
Mr.
idea?
Yes,
Senator
Mr. Chair, and
McEwen?
I'll just say that critical incident reviews are incredibly important because it looks at critical incidents not from like a who's to blame, but where might there have been a system failure and how do we fix that? And so it's actually a really important part of ensuring that people have safe places to live and work and thrive in Minnesota.
And I will note that there is a provision in the bill that this review process does not replace the process of screening or investigating cases of alleged maltreatment and so on. Senator Limmer.
Thank you, Mr. Chairman. I don't know if this question is for the author or for our testifier or counsel. Is there a definition of what a critical incident is? And if not, should there be a definition of what that is in law?
Ms. Grom.
Mr. Chair, Senator Limmer, I'm just looking through the bill right now. I don't believe we have a definition for critical incident, but we do define in paragraph B, cases selected for systemic critical incident review. And so that kind of outlines the parameters of what the incidents that we would look at would include.
25.17, Senator Limmer.
25.17.
.17.
And Mr. Chair, Senator Limmer, I'll add that
Ms.
this
Grom.
language is very similar to the critical incident reviews that we do in this same section, in the same chapter 256, for child's critical incidents and fatality reviews.
Okay. Senator Limmer, I'll note that on page 24, beginning of section 22, it looks like the progenitor of these incidents are incidents that are reviewed, that are reported as required under the maltreatment of vulnerable adults statute. And then I presume from among those reports, the review team would select whatever they think is appropriate to review for more systemic analysis. Is that a fair conclusion, Ms. Grom?
Mr. Chair, yes.
Mr. Chair.
Senator Limmer.
Just reviewing page 24, I was beginning to read it as testimony was being conducted. It seems like this could be a rather fluid team effort by looking at the actors that would be enrolled in it. Actors may include, starting on 27, staff. How many staff? I don't know. Lead agency staff? I don't know the quantity there. Department of Human Service staff, without a quantity. Looking at this and knowing how government sometimes works, you could have quite a few people reviewing, tied up on one incident. Is that a practical consideration that I'm raising or not?
Senator Maye Quade.
Mr. Chair and Senator Limmer, I'll respond first, and then Ms. Grom can fill in anything I might have missed. Part of the important part of critical incident reviews is to bring about a learning point or a focus of the study. And so the reason why you see kind of this may include list is who it may include depends on the type of incident. So maybe you had a wheelchair safety incident, and that might involve people who live in the house and maybe a PCA and somebody from the department, or maybe you had a person who leaves the home unexpectedly. So maybe it includes public safety in that area or county services in that area, and then people in the home. And so because the incident types kind of range, that's why you see that range here. It's not necessarily tying all these people up in every critical incident, but when they're looking at critical incidents that are selected for this kind of review to find that learning point, these are the folks that it could include.
Thank you.
Any follow-up, Senator Limmer? Any further questions or discussion from members of the committee? Senator, any members of the public wish to weigh in on this? I'm not seeing any. All right, members, I'm informed the next stop for this bill is the Senate floor. So Senator Umu Verbatim moves that Senate File 1900 be recommended to pass and be sent to the Senate floor.
Thank you, Mr. Chair, members of the
All those in
committee.
favor say aye. Aye. Opposed? Motion prevails. You are welcome, Senator Maye Quade.
Thank you.
You in here and ready to go? Okay. Members, the next bill on our agenda is Senate File 754, Senator McEwen. Welcome to the Judiciary Committee. Why don't you go ahead and tell us what your bill proposes to accomplish, Senator?
Very good. Thank you, Mr. Chair, members. It's a pleasure to join you this afternoon. Senate File 754 is about basic fairness and reducing barriers for small construction businesses. This is a common sense bill. It has bipartisan support and authorship, and it has the support of 24 organizations, including labor unions, management, the trial lawyers, and the Minnesota Council on Latino Affairs. Senate File 754 is often referred to as the duty to defend bill because it ensures that each party to a construction contract only has to defend to the extent of its own negligence. The bill realigns the concepts of indemnity and defense and revives the spirit of the 2013 indemnity law. It does so by doing three things. First, it ensures that a negligent party pays their own legal fees. 2, it aligns Minnesota practice with the American rule. And 3, it removes ambiguity to ensure that the public projects we fund are performed fairly. I think the Minnesota Council on Latino Affairs said it best in their letter of support for the bill, and I'll just read a couple of sentences from that letter. Quote, increasing contract opportunities for disadvantaged businesses, particularly those owned by people of color, is a necessary step in creating a more equitable economy. Non-negotiable duty to defend contract terms create barriers for small businesses, thereby hurting our economy and workforce. Thus, we believe that the allocation of risk should be equitable and that all parties should be held responsible for their own negligence. Ensuring basic fairness to Minnesota construction contracts will help small businesses, businesses owned by economically disadvantaged and historically disadvantaged groups, and workers across the state, end quote. Mr. Chair, I have Mr. Patrick Lee O'Halloran here to testify, as well as a couple of other testifiers, Tamara Sunby and Paulita LaPlante, in support of the bill. And that concludes my presentation. And I also, I should add, Mr. Chair, we do have an amendment.
Senator McEwen, would you prefer to address your amendment before the testimony? The amendment, is it a predicate for any of the testimony we're going to hear?
Yes, I think that would be a good idea, Mr. Chair, to go ahead and address the amendment first, and then the testimony can, and the discussion can flow from that.
All right. This is not your first committee stop, so Senator McEwen, members, you have the A1 amendment in your packet. Senator McEwen, if you could please tell us what your amendment proposes to do.
Yes, I'll just give a brief synopsis, and then I will ask also my expert who's joined me here at the testifiers table to perhaps say a few words as well, making sure that I've gotten some of these terms of art right and correct. But what this amendment is, Mr. Chair and members, is really a sort of emblematic of an effort toward good faith. We have had a lot of discussion around this bill and trying to make the bill as workable as possible, meeting the needs and concerns of public owners, meeting the needs and concerns of the representatives of general contractors in as much as we can, and just really making this bill as workable as possible. So this language keeps project-specific insurance still applicable within the bill. It simply modifies it, though, so that the insurance goes to one's own negligence. It keeps that project-specific insurance in there as long as it is geared toward, specifically toward one's own negligence. So it keeps the spirit of the bill, but it also specifically notes that product-specific insurance in that line. And then the second part of the amendment, so that's the first part of the amendment, and the second part likewise aligns that language and mirrors it. So with that, though, I would ask my expert here if he has some more specificity to add about what the amendment does.
Mr. Lee O'Halloran, welcome to the committee. Go ahead and state your full name and your affiliation and proceed.
Thank you, Chair Latz and members and senators. My name is Patrick Lee O'Halloran. I am chapter counsel for the Minnesota Subcontractors Association. I'm also a private attorney in private practice. I've been focused on construction law for more than 20 years. The amendment specifically addresses some concerns that have been raised by some folks in this process, public owners, the Bar Association, the Associated General Contractors, had all characterized the bill as removing project-specific insurance from construction projects. And to my view, it didn't actually do that, but this is really some comfort language. If you look at the bill on page 2 where the amendment goes, the section right before the amendment is 2B, so lines 2.7 through 210. That's the prohibition that the amendment is part of the exception to. The prohibition says you can't require someone to obtain insurance for the upstream party's own negligence, basically. And paragraph C, this is all part of, this is already in current law. It looks like an addition because this is part of the bill that adds it to Chapter 15. But current law on 337 has these same provisions, and it says that there's some exceptions to that prohibition, one of which was project-specific insurance. We sought to remove that in the bill because there are some folks out there that are making an unscrupulous argument that that gives them carte blanche to have a huge loophole for insurance provisions that are done one project at a time, where they could have an endorsement that would require you to insure the general contractor for its own negligence, so long as you did it one project at a time, one endorsement at a time. And so that was the purpose of the bill as drafted, was to take that out. But to address the concerns that we are removing the ability of anybody to use project-specific endorsements, the amendment returns that language and simply clarifies that project-specific insurance can be required so long as it is for claims arising out of the promisor's own negligent acts or omissions. So it's sort of clarifying comfort language of doing what we felt the bill already did, which was to only prohibit that in the circumstance where you're doing these broad form defense provisions.
So I have a question for counsel on this, just a drafting question on the A1 amendment. On line 1.6 and also on line 1.11, the word promisors there, but it appears to be used in a possessive manner. Does it need to have an apostrophe?
Good question.
Mr. Lee O'Halloran, you're an attorney. What's your thought on that draft?
I'm nodding along. I think you're exactly right.
And where would you place the apostrophe, before or after the S?
I'd put it before the S.
Senator Seeberger, would you like to move the adoption of the A1 amendment incorporating those two apostrophes were just noted?
So moved.
Any discussion from members of the committee on the A1 amendment? All those in favor say aye. Aye. Opposed? The motion prevails. The amendment is adopted. Mr. Lee O'Halloran, do you have anything else you'd like to add in connection with testimony in support of the bill at this time?
Yes, please.
Go ahead.
I won't reintroduce myself. I agree with Senator McEwen that this bill is needed because there is significant imbalance in bargaining power in the construction industry, which is leading to unfair shifting of legal costs and insurance costs onto the smallest subcontractors in Minnesota. This bill stems from the 2013 amendment to the anti-indemnity statute, which made broad-form indemnity agreements in construction contracts unenforceable, except to the extent of the promissor's own fault or negligence. That was simply a clarification of what we called then the kindergarten rule: each party cleans up their own mess. After that law was passed, lawyers for unscrupulous general contractors started drafting contracts that would get around the spirit of that law by creating overbroad obligations to defend that would apply in situations where an indemnity wouldn't be legal under the 2013 law. So instead of having overbroad indemnity provisions, they just had an overbroad defense provision that would still require parties to indemnify upstream contractors, even if those upstream contractors were negligent and solely negligent. We've got an example in your materials of an actual contract between a general contractor and a disabled veteran subcontractor on a MnDOT job. That contract provision requires the subcontractor to pay for all of the general contractor's legal fees throughout a dispute, even if the subcontractor didn't cause damage and can't be legally required to indemnify the general in that situation. Today in Minnesota, subcontractors are regularly being contractually required to defend the general contractor, even when the general contractor is solely negligent. That practice is unfair and creates a host of problems. For one, those duty to defend clauses are common and often non-negotiable, so the question to the subcontractor is either sign this unfair provision or don't get the work. If the subcontractor wants the job but won't agree to the terms, they have to incur additional legal fees to try and negotiate away those unfair terms. If they do sign the contract, those terms impact the way they approach the entire jobs and chill their use of other legal remedies in their contracts, leaving many subs to feel like they have no legal options. We also know this practice hurts disadvantaged businesses trying to make headway in the industry. They face increased risks and costs to cover risk shifting. There's a quick quote from the 2017 Minnesota Joint Disparity Study on Department Administration. Quote, "Duty to defend contract requirements, retention, withholding, and prompt payment issues cause challenges for small firms in the Minnesota marketplace." And another, quote, "Public sector insurance requirements are a barrier to businesses seeking public sector prime contracts and subcontracts," close quote. If a claim does arise, subcontractors can and do face the risk of significant liability, even if the claim arises outside of their control and they're not responsible for it. If the claim is going to be settled, which most claims are, the first thing the parties look to determine who pays what is the contract, often with the same terms from that contract you've just seen. So unfair settlements are getting structured because of this practice. When a similar risk transfer provision afflicted the Minnesota trucking industry, this legislature passed the law to prohibit that. That's Minnesota 221.87. The trucker statute uses the same indemnified defendant home harmless language as this bill proposes. Numerous states in the Midwest have near identical laws limiting indemnity and defense to the same extent this bill proposes, including Iowa, Oklahoma, Colorado, and Montana. Passing this bill will put Minnesota in line with the more common trend, which is limiting unfair risk transfer to a reasonable extent. I'll quickly walk you through the bill. For sake of ease, we start on page 2, section 4, line 2.22 adds the word defend to the definition of indemnification agreement in chapter 337.01. This closes that loophole I just talked about that would allow a negligent party to make someone else pay for it and insure their legal costs. Just like the current law for indemnity agreements, the addition of the word defend means that separate defense obligations would only be enforceable to the extent of a party's own fault or negligence. Next, section 5, line 3.3, was dealt with that project-specific insurance. We've talked about that, and that's been handled with the amendment. I think that's, the point is that, again, I've covered that. I don't need to repeat that. Finally, sections 1, 2, and 3 of the bill ensure parity between public and private projects. It does so by taking the current language from 337 and all the changes just mentioned and putting that language into the public section of statutes 1571 to 1572. That's because there's been an argument that there's certainly an argument 337 already applies to state agencies, but some of the agencies have argued that that doesn't apply to them. So that argument means that, at least for some of those agencies, they believe their construction projects have no indemnity laws that apply to them or no anti-indemnity laws that apply to them. I disagree with that argument, but it's been made, and we want to make sure that Minnesota projects are performed fairly, whether they're private projects or public projects. And they create business opportunities for everyone. It's important to note, if this bill is passed, a general contractor can still require a subcontractor to pay for and insure the general contractor for any costs related to that sub's own fault or negligence. It's important to mention because I've been hearing some disinformation on this point of folks saying, well, we're doing away with any obligation for subs to defend generals. That's not the case. The right to require somebody to be responsible for their own fault is protected in 337.02 and in the amendments to Chapter 15. The right to require insurance coverage to protect for vicarious liability is specifically protected in 337.05. This bill doesn't change that and, in fact, imports that change into the public projects. There's a lot of support for the bill. 25 organizations now actually support the bill. And believe the status quo needs to be changed to make a clear and fair public policy. In closing, this bill is just about fairness and removing barriers for small and emerging businesses, as well as leveling the playing field for contractors who use reasonable contract terms. I urge you to pass the bill, and I'd stick around if there are any questions.
Thank you, Mr. Lee O'Halloran. I have signed up to testify a Tamara Sundby and a Polita LaPlante. If you two are present, come on forward. Mr. O'Halloran, if you'd vacate your seat, make room for new testifiers. Come on forward, and we'll start with Ms. Sundby. If you could state your name for our record, identify your affiliation, and proceed.
Thank you, Mr. Chair, committee members. I'm Tamara Sundby, and I'm proud owner of GTS HVAC Incorporated. We are a woman-owned DBE disadvantaged business enterprise heating, ventilation, air conditioning company. We've been in business for 17 years, and we have 3 trucks in the field. We've made it through the pandemic and are working to get back on our feet again, and I hope to stay in business for another 17 years. I hope to hand my business down to my daughters or my sons one day, but many of the contracts we're being asked to sign could put us or my business out of business in the blink of an eye for someone else's mistakes. The defense demands that some general contractors and public owners are requiring they put my business on the hook for their actions and their lawyers' fees. It's not fair, it's not right, and it's got to be fixed now. Why should I have to pay for or insure someone else's mistakes, especially someone who I have no authority over? Seriously, I ask myself, how is this even legal in Minnesota? Public owners are begging small, women-owned, minority-owned, disadvantaged business enterprises like myself to come on board on public projects. Yet, they're expecting us to sign these unfair contracts. You have an article in your materials about MnDOT failing to meet their own DBE goals. In that article, it feels like they're actually blaming the DBEs for failing to meet these goals. But how can I even consider jobs when I have to sign their non-negotiable contracts and enter into these contracts that are very, very risk-filled? I have had to turn down a number of jobs or potential job opportunities, both public and private, because of these non-negotiable defense provisions. It's impacting the growth of my business, and I've also had to hire attorneys to argue terms before I even know if I get the job, which means I'm actually paying for the project I may not even get. And if I do get the job, I already have that lawyer's fee and it's cut into my margin, so I have to perform perfectly on the project. I know many of my peers are signing these contracts so that they can get work. And I know many of them are signing them that don't understand the amount of risk that they're taking on. And they're being, or worse, they're being shamed or bullied into signing them. This leaves only a legislative option, which means we need your help. I'm testifying today because I want to help end this absurd and unfair practice for myself and others. It's a bit daunting, but I'm proud to be testifying here today with another woman-owned business and in the midst of Women in Construction Week. We are willing to stick up for our industry even when no one else will. Please help us. You are our option. Pass Senate File 754 and bring some common sense back to Minnesota construction contracts. Thanks for your time. If you have any questions, I'll answer.
Thank you, Ms. Sunby. Ms. LaPlante.
Thank you, Tamara. Mr. Chair, committee members, my name is Paulita LaPlante of Inver Grove Heights and owner of Prescription Landscape Incorporated, a woman-owned business enterprise that was founded in 1980, is headquartered in St. Paul, Minnesota, with branch offices in Crystal, Shakopee, and Sauk Rapids. Duty to defend reform is important to equity in construction contracts. Prescription is a privately held, locally owned commercial landscape company with approximately $40 million in revenues, depending on total snowfalls. We employ a year-round staff of 150, grow to twice that size in the winter. We have multiple land care service lines, one of which is landscape construction. That service line is our only union division, and it is less than 10% of annual revenues, deliberately so. Most of the jobs we bid are large, so we routinely subcontract aspects of the landscape work to WBE, MBE, and DBE subs with whom we have had years-long relationships. This helps their businesses, since we pay for the insurance to indemnify their work and can afford bid bonds when required. While this sounds great, we are leery of growing our construction service line because the contract language from some of the contracts on which we bid can shift all the risk of loss to us, even if there is the thinnest nexus between the claim and our work. Unlike Tamara, our company can afford to turn away work if it poses too great a liability risk for us. However, that means we are also turning away work we would be able to give our subs as well. You've had the opportunity to read contract language, but the clause that always causes us to reject work includes the statement, quote, contractors' work or presence on the property, including but not limited to any negligent acts, end quote. The practical effect of this chilling language shifts the entire risk of loss to our shoulders for an unknown universe of claims. We are 100% willing to indemnify our work and that of our subs as it is defined in our contract scope of work. However, when a contract includes broad statements about our very presence on a property, it is easy to see that definitions can become obscured and legal risks heightened. Our insurers rightfully balk. I respectfully request that you pass Senate File 754 and enable us to continue to grow our business and to contribute to the growth of our small business partners. Thank you.
Thank you, Ms. LaPlante. I have two other testifiers that signed up, Cameron Boyd and Patrick Hines. If you would come forward and occupy the vacant seats at the testifier table. Mr. Boyd, we'll start with you. So go ahead, identify yourself for the record when you're ready. State your affiliation and provide us with your testimony.
Thank you, Chair Latz. My name is Cameron Boyd, and I'm the General Counsel with the Metropolitan Airports Commission. I'll be pretty quick today, and I guess I have a very full agenda ahead of you. I wanted to first confirm that you all saw the letter that I believe you should have, a letter signed on from 6 different agencies coalesced in opposition to the bill: the Department of Administration, the Metropolitan Airports Commission, League of Minnesota Cities, Department of Transportation, the Minnesota Intercounty Association, and the Association of Minnesota Counties. All join in opposing this bill. Generally, the Airports Commission supports the reduction of barriers to participation for disadvantaged businesses and for all small businesses for many reasons, not the least of which is that it fosters more competition, which in fact drives down bid pricing for us. We also support the idea that parties should be responsible for their own fault, which is what this bill is really driving toward. We do not oppose Senate File 754 as it applies to indemnity for this reason. Some of the testimony by supporters of the bill in this committee and in others earlier this session suggests that there is some confusion about what sorts of claims this would cover. This is only intended, by its definition, indemnity and defense only apply to third-party claims. It does not address problems for a project owner that the construction does not deliver what was contracted for, or cover disputes among payment between contractors. So the problem is not indemnity, the problem is with the duty to defend. Senate File 754 says that the duty to defend only applies to the extent of the promissor's fault. That's actually nonsensical because fault is not yet determined. That's what the underlying litigation related to the claim is there to resolve. Instead, the bill ought to tie the defense obligation in some fashion to the nature of the claim asserted, rather than to a determination of fault. The concern that we have is that a contractor that, based on the claim, may well have fault, their work is related to the subject matter of the claim, could deny or decline the tender of defense for the sole reason that it says, I'm not at fault. And that determination has not been tested in court yet. This would leave an owner such as the Airports Commission to defend itself from claims for which, based on the claim again, it clearly has no potential for fault. Fundamentally, the contractor whose work is at dispute in the claim should be the party to defend the claims. And this does not change the fact that at-fault parties will be responsible at the end of the day. Altering the duty to defend or leaving the changes to the duty to indemnify, but changing from the amendment from the bill, the duty to defend, would not address all responsibility for loss. We're only talking about the conduct of defense. The actual damages that are found after fault is assigned are not really what we're talking about here with regard to the duty to defend. That's it for my comments. Thank you.
Thank you, Mr. Boyd. Mr. Hines.
Thank you, Mr. Chair and members. For the
I'm
record,
sorry, I'm going to interrupt. Mr. Boyd, you mentioned a letter that it was submitted electronically, and we are having it distributed electronically to the members of the committee right now.
Thank you, Chair.
Thank you. Mr. Hines.
Thank you, Mr. Chair and members. My name is Patrick Hines with Messerly Kramer. In order to streamline testimony, I'm appearing on behalf of both the Minnesota Contractor Coalition, which is an organization of 8 of the largest general contractors doing business in Minnesota, and also the Associated General Contractors. I want to thank Senator McEwen for her work on this bill, and in particular over the past 10 days or 2 weeks. I'd like to note that we still are in the process of trying to work out some compromise language. The public owners and general contractors provided an amendment to the Subcontractor Association and to Senator McEwen about 10 days ago. Senator McEwen and Senator Seeberger convened a meeting with at least 12 people in a conference room for an hour speaking about the bill, and a lot of time speaking about Section 5 of this bill, which is also the subject of the A1 amendment, having to do with project-specific insurance. After that meeting, the State Bar Association weighed in with a letter that is in your packets. I'll note they only weighed in on the second piece of the bill, the project-specific insurance piece, and said that they oppose that provision. After that letter, the A1 amendment was posted, which attempts to make some changes to that section of law, or the section of the bill. We don't believe that the A1 amendment corrects the problem. I'll get to that in a minute, but I would like to note also, I know we don't talk about the other body very much, but the companion to this bill.
Try not to talk about them at all, Mr. Hines.
Right. I think in
But
this
go
case.
ahead. Just don't mention their name.
I won't. So the companion to this bill was given second reading yesterday by the other body. So it's met first deadline, and we have 2 weeks before second deadline here. So as we continue to work in good faith, I think I would ask the committee to consider whether it makes sense to have the exchange of amendments come back to this committee within the next 2 weeks before sending it on to the floor, as opposed to having the work done outside of the committee process and then being brought to the floor. This isn't a delay tactic because the bill could easily meet the deadline if it came back to this Judiciary Committee in the next 2 weeks. So I'm just putting that out there. Regarding the A1 amendment and project-specific insurance, Mr. Boyd talked about...
I'm going to interrupt you for just a second. The letter that you mentioned was also submitted electronically, and it has been distributed by email to the members of the committee. So members, you can find it in your email inbox. Thank you. Go ahead, Mr. Hines.
Thank you, Mr. Chair. Mr. Boyd talked about the duty to defense provisions, and I won't repeat his testimony. So what I'm looking at is Section 5 of the bill as amended by the A1 amendment. And this has to do with project-specific insurance. And I would suggest it doesn't need to be in the bill at all in order to deal with the concerns that the proponents raise about the duty to defend. Project-specific insurance is a pretty broad term, and it covers a lot of issues. And I'll talk about one example of project-specific insurance to try to illustrate what our concern is. Pollution insurance is a very common form of insurance that contractors, generals, subs, owners will get on projects. And if you look at a project that might be, for instance, adjacent to the Mississippi River, the danger of a spill in terms of the liability and the pollution is far greater if you have a construction site on the shores of the Mississippi River than if you do in an abandoned farm field. So the owner or the general contractor may say to a sub, your current general liability policy only has $1 million in coverage. And because we're adjacent to the river, we want coverage up to, say, $10 million, because if something bad does happen, it's going to be very expensive to clean up. So they want project-specific pollution insurance for that. Many subcontractors also hire additional subcontractors. So they may have a trucking company that's delivering material. They may have additional subs coming. Project-specific pollution insurance will cover multiple tiers of subcontractors to make sure that the project is adequately insured. That helps the owner, the general contractor, and all tiers of subcontractors down the line. Not to mention the fact that it helps the state of Minnesota in the case of a spill that needs to be cleaned up and needs to be paid for. The A1 amendment would call into question whether pollution insurance, project-specific pollution insurance, could be required, because it actually does not simply deal with the claims arising out of the promisor's negligent act, because that promisor many times will hire additional subcontractors, and the pollution insurance is designed to cover all of that. So that's just one example of why we believe the project-specific insurance language should simply be removed from the bill. I believe it's in there because of a fear that the prohibition on indemnification and liability in the first part of the bill and the underlying statute could somehow be avoided by project-specific insurance, but nothing in the statute that allows project-specific insurance says you can use it to do an end run around the anti-indemnification statute. The anti-indemnification statute is still there, and it applies to any insurance policy. So we think, while we don't agree with the underlying premise of the bill, we would ask that that section regarding project-specific insurance simply be removed, because it calls into question many insurance policies that are used, and I think that's why the State Bar Association has weighed in at this point on that specific provision. So again, we'll work with Senator McEwen. We'll continue to work and exchange thoughts and ideas as the process goes forward, and maybe we'll be back in front of the Judiciary Committee with some language that everyone agrees to. Thank you.
Thank you, Mr. Hines. While you two gentlemen are up here, since that's the end of our at least listed testifiers, I should ask, is there anyone else in the room who wants to testify in connection with this bill at this time? I'm not seeing anyone. Members, the anticipated plan was for this bill to go on to Finance Committee.
Correct.
Some issues have been raised with regard to issues that would be within this committee's jurisdiction, should there be any action desired by this committee along the lines suggested by our last two testifiers. This whole matter has been around the legislature for at least a decade. I was really heavily involved in discussions years and years ago about this. So I'm a little bit surprised that we are on deadline day and there's still proposals for changing any kind of or trying to find a stakeholder agreement. I mean, it should have been done 9 or 10 years ago, certainly not today. So I'm pretty frustrated to be hearing this now. Maybe the prospect that the bill is actually moving has generated some more willingness to work on this. I don't know. But while these two gentlemen are at the testifier stand, I should ask the committee if there are any questions for Mr. Boyd or for Mr. Hines in connection with this. Senator Kroon.
Thank you, Mr. Chair. With regard to the project-specific insurance, I'm just wondering, and you referenced a letter, this is from Mr. Hines, I guess. You referenced a letter by the MSBA. I'm curious whether that letter came before or after the A1 amendment. And it could be for the chief author as well.
Mr. Hines.
Mr. Chair and Senator Kroon, the A1 amendment did not come from our group, so I don't know when it was drafted, and maybe Senator McEwen would know better, or one of the proponents.
Senator McEwen.
Thank you. So the A1 amendment was drafted after discussions with, and meetings, several meetings, in an attempt to provide a little more peace in the valley. I think, though, that at the end of the day, we may just have to agree to disagree. Sometimes, you know, we work really hard and sometimes over years to try to find language that everyone can agree on. But there are, as we all know, some issues where there are just going to be parties that disagree.
Senator Kroon.
Thank you, Mr. Chair. Yeah, I was just trying to figure out the timing on that because it seemed like there was something about MSBA having a concern, and I'm just wondering whether that, their concern, not the general contractor's concern, whether their concern was addressed through the A1 amendment. I don't know if, Mr. Leo Holler, you had your hand up. I don't know if you could shed more light on that or not, but and we can come back to that too. I had one more question. Well, on the A1 amendment, and the example was pollution, project-specific insurance that was given, and whether or not the word promisor would encompass subcontractors of subcontractors or multi-layered tiers of subcontractors. I mean, wouldn't, though, a promisor encompass the subcontractor or anybody working on their behalf, including other subcontractors?
Mr. Hines.
Mr. Chair and Senator Kroon, the way that we've read the language is that it would not, because typically each contractor or subcontractor will have their own insurance, and if I'm the subcontractor if I'm performing the landscape work, I'm asked by the owner to provide project-specific pollution insurance. I'm the promisor, and I provide that insurance. I would have to require by contract of my downstream sub in order to get them to make the same promise, if you will, on the insurance. So I don't think that language covers sub-tier subcontractors.
Senator Kroon.
Thank you, Mr. Chair. I'm not sure if I understood that. It seems to me, just looking at the plain language of it, that in general construction law and how that would work, that it would include that. But and then I had another question for Mr. Boyd about, you said that the duty to defend language that's standard, or I don't know if it's standard, I guess, but that the example we're giving that some general contractors are using, including apparently state contractors, you said it was nonsensical because indemnity or liability isn't determined until the end, but isn't that the case, all the time when we're talking about duty to defend and duty to indemnify? I mean, yet I'm not familiar with a duty to defend that's not accompanied by a duty to indemnify. That's what I'm struggling with here. And regardless of when liability is determined, it seems like you would have the duty to indemnify is what triggers the duty to defend. So maybe you can shed light on that a little more.
Mr. Boyd.
Thank you, Chair. I would say that the duties are separate and distinct under Minnesota law. I'm not familiar, frankly, with whether a duty to defend has ever been found to exist where there wasn't a corollary duty to indemnify, but they are obligations that theoretically apply at different moments in time by their very nature. The duty to indemnify is going to address the ultimate liabilities for the fault as it's apportioned, whereas the duty to defend arises at the onset of the claim, again, as I expressed earlier, because fault is not yet known. And as I suggested during my comments earlier, if the bill had some rational tie to the claim itself in some fashion, that would potentially make sense. But to tie it to fault is just nonsensical.
Mr. Chair.
Senator Kroon.
Thank you. I realize those are two separate concepts, and it's somewhat common to have a duty to indemnify without a duty to defend. It's the other way around, and I think you kind of stated that that's not how it typically works, and I'm just wondering why we would allow this, in this case, to have a duty to defend without a duty to indemnify. What's special or unique about this if it's almost never done?
Mr. Boyd.
The Airports Commission would not ever do that. Our forms would not obligate that. If you were to have the duty to defend without the duty to indemnify, why in the world would a party want someone else to defend a claim that could ultimately have liability landing on your doorstep? So it's not a practical risk.
Mr. Hines.
Thank you, Mr. Chair and Senator Kroon. I guess I would just add that the duty to defend kicks in almost immediately upon the initiation of a lawsuit. So if I'm again, we'll just landscaper, if I installed an irrigation system, the system fails, it floods a home or business and causes damage, I, the subcontractor, get sued. At that point, I take the complaint, which in Minnesota would be very thin because we have notice pleading. I send it to my insurance company. The insurance company looks at the complaint and asks just a few questions. Is the defendant, do they have an insurance policy with my company? If the answer is yes, then the question is, was the insurance policy in effect at the date of the alleged negligence? If the answer to that is yes, really the only other question is whether the scope of the policy applies to their work, so that it says you're the landscaper and you install irrigation systems. That's what the policy is protecting against when you get sued. Once those questions are answered in the affirmative, the duty to defend kicks in, and the insurance company will hire defense counsel to provide a defense. Now, what happens relative to the general contractor and the owner is, by operation of Minnesota statute, the general contractor and owner are vicariously liable for the work of the subcontractor. So in that complaint, it will typically say, based upon information and belief, the general contractor on this project is Acme, and they're vicariously liable for the fault of the subcontractor, therefore we're suing you. So, but the lawsuit is about the work performed by the subcontractor. And so defending that work it should be the obligation of the sub because they're defending their own work. They're not defending, the general contractor. They're defending the work that they perform. And I think that's why the distinction is so important, because even if the duty to defend and indemnify are tied together, the insurance company will meet its obligation to defend, typically under a reservation of rights, and they will say, if down the road we determine through discovery that, there's a reason we won't defend you, then they'll withdraw it. And so if the general contractor is not found to be negligent, if there's no reason for the general to be indemnified, then the issue's moot. But that duty to defend is still important because it is generally, the general contractor is involved because of statutory vicarious liability, not because they performed any of the work that's the subject of the lawsuit.
Senator Kroon.
Thank you, Mr. Chair. I do understand reservation of rights. I understand they're separate concepts, but in your example, the insurance company, while there may be coverage issues that might have to be determined down the road, ultimately, they're defending because of their overall duty to indemnify under that policy. And that's what I'm struggling with. I'm not seeing the connection to the general contractor, subcontractor. I mean, if the claim is that the subcontractor was negligent, then I don't see anything in this bill that would change their responsibilities and their obligations. But maybe I'm missing that, because that's how it seems to me. So maybe if I back up and ask, what happens, I guess, maybe my next question is, what happens if there's a claim that alleges negligence by both the general and subcontractor? Would this bill allow a general contractor to still be able to require a subcontractor to cover the entire defense in those situations? Or would each party be responsible for their own defense? And maybe that's a question for Mr. Leo Holleran. I don't know. I'm just trying to get the lay of the land here because I'm not seeing the connection at this point.
Mr. Boyd.
Senator Kroon, I would say that the difference between the duty to defend and indemnify in your scenario there is that after the trial, once the liabilities have been apportioned and the damages established, the duty to indemnify can be applied retroactively to all the parties that are involved. The duty to defend, however, the conduct of a defense must occur, obviously, during the defense. So there is no way to go back and correct that after the fact.
I have a question. Wouldn't it be in the subcontractor's best interest to make sure they are adequately insured against polluting the river in the unlikely event of a claim? Certainly a claim of that nature, if they're found liable, would completely put them out of business. Without the contract, without the general contractor requiring it? Or do you think there are enough subs that would just take the chance and assume that there's going to be some way for the general contractor to be brought into it to cover any losses? Mr. Hines?
Mr. Chair, thank you. I agree with the statement. It's in everyone's best interest to be adequately insured. I think I think a couple things may happen. It may be in the subcontractors, it may be their desire to simply maintain a CGL, general liability policy, for all of their work. And that policy will have limits, have per occurrence limits, and then we'll have total policy limits. And there is the possibility in a large claim with pollution or something else that their CGL policy is going to hit its limit at some point if they were involved in multiple lawsuits, and then it will not have sufficient liability coverage. I think there also may simply be, subcontractors or any contractor may underestimate the amount of liability that their work has and decide, instead of getting a separate policy, I'm going to have my own policy, and because I think that's okay. So at some point, I think it's incumbent on the owner or the general contractor overseeing the entire project to make an assessment and say, because of the proximity to the river, or because this is in a residential high-rise that's a homeowner association, we feel more likely that there's a lawsuit for that than for an apartment building. We think there needs to be project-specific insurance because ultimately they're trying to manage the risk for the project. So it would be in their best interest to be adequately insured, but I think there are likely times when that doesn't happen.
Can't the general contractor include in their own insurance coverage the potential that a subcontractor is going to be underinsured and the general contractor might be on the hook for something more? Or get an umbrella policy? I don't know if that's even an item in construction law. We get a secondary insurance coverage in the event that the limits are pierced in a particular case on the first insurance?
Mr. Chair, if I haven't crossed the line already, I'm getting perilously close to crossing the line to a level of specificity on insurance policies that I might not be the best person to answer that question.
Yeah. Mr. Boyd seems
Well,
willing to
I'm not
wade
going to call
in here.
myself a true expert in this area, but I don't know whether there's a specific policy that a contractor or owner could get to cover underinsurance, so to speak, for a subcontractor, but there are OSIPs and CSIPs which seek to create a single-party sort of managed insurance structure which would address the liabilities from any of the parties involved. They tend to be expensive, but they do address, I think, the point that you're driving toward there.
I mean, if nothing else, Lloyd's of London would probably find a way to provide coverage for these. But they've had their own issues over the years. Mr. Boyd.
If I could make one more comment on the A1 amendment. Looking at line 1.6, that's where we're addressing the project-specific insurance, and it goes on to say for claims arising out of the promisor's negligent acts or omissions. And I wanted to highlight the point that we've, in the context of discussing this bill, talked at times about insurance for the defense obligation versus insurance for the underlying liabilities. And this language is not perfectly clear as to which is intended, but use of the word claim and also with the promisor's negligent acts once again creates a bit of a timing conundrum where if you're talking about insurance for liabilities or ultimate damages, then we don't yet know, who was negligent. And so on the front end, you wouldn't necessarily know whether that policy complies with the requirements of the statute or not.
Senator Kroon.
Thank you, Madam Chair. I understand, okay, I'm trying to piece this together and trying to get your argument, and I think it might have to do with vicarious liability to the general contractor based on the negligence of a subcontractor in a scenario perhaps where the subcontractor isn't named as a party. Is that what we're getting at? And if so, couldn't the general contractor just simply third party in the subcontractor based on their own negligence in that case?
Mr. Boyd.
I would expect so, and candidly, the concerns among the contractors and subcontractors are a little less germane to my specific interest on this. My interest is primarily between a project owner and the general contractor, so I haven't considered that specific question.
Senator Kroon.
Thank you, Madam Chair. And then the follow-up question to that is I'm trying to isolate a situation, given the contract language that is used here, where the allegation is a negligence against, let's say, the general contractor alone, and there is no allegation that the subcontractor is negligent. Nevertheless, this language would still ensnare the subcontractor to pay for the defense of the general contractor. And I think that's the primary concern of the author and the subcontractors here. And the way I read it, they're on the hook for that.
Mr. Boyd.
That I agree is a concern, and that's where I say in our practice that's never happened to our knowledge. But that's where a relationship to the claim, as I proposed earlier, would make more sense than a relationship to fault, which obviously is not yet known.
Senator Kroon.
Thank you, Madam Chair. I just think that the remedy that's being sought here is for subcontractors to not have to pay for the defense of a general contractor when there's no claim that the subcontractor was liable. And the concern I'm hearing in rebutting that is there could be some concerns about the general contractor having to pay for the subcontractor's negligence through some sort of vicarious liability. And I think there's ample opportunities in the law for the general contractor to address those situations without putting this onerous clause in the contract.
Go to Chief Author, Senator McEwen, and then Mr. Hines.
Thank you, Madam Chair. And I think that it would be very good to make sure that everyone has the opportunity to respond to this good discussion. I just want to make sure that we have an opportunity for the committee members to hear again from our expert on the bill, Mr. Leo Halloran, for any responses to this discussion as well. And also, Madam Chair, we do have an official from MnDOT here who I would like to have an opportunity to just offer a little testimony and insight from the public owner side. Thank you.
Absolutely, Senator McEwen. So I will go to Mr. Hines. Mr. Boyd, if you have anything to add, and then if you can bring those two folks forward, Senator McEwen, we'll go to them next.
Thank you.
Mr. Hines.
Thank you, Madam Chair. And Senator Kroon, to your question about whether a subcontractor would have to defend a general contractor for the general negligence, that's not occurring because, and again, sometimes it's difficult when we only speak to one piece, is that the insurance policies themselves are limited to the work of the subcontractor. So if the subcontractor has a policy to cover its work, that prevents the subcontractor from being on the hook for paying for either defense or liability or indemnity of other people's work. That was really the heart of the issue 10 or so years ago when the subcontractors said, hey, the way that these insurance policies and the law is working, there are times when I'm, as the landscaper, ending up paying for the negligence of a roofer. And when they came to the legislature, there was case law where that had actually happened, and that's, in my opinion, why the compromise was worked out the way it was, to say, look, you're not going to be indemnifying people for other people's problems. And so that was taken care of. Defense was left out specifically because, as Mr. Boyd noted, it occurs immediately, and it has to be dealt with. But the scope of work that's covered by an insurance policy prevents the landscaper from having to do the work to cover the cost for the roofer, because the insurance company is not going to do it. And I'll sit down.
So I missed a little bit of the discussion. I apologize, but it seems to me that the general contractor's insurance, the insurance policy typically includes the duty to defend as well. So the general contractor who's got statutory vicarious liability for the subs is going to have insurance that's going to include a duty to defend for any vicarious liability arising out of subcontractors' actions. The insurance company will have the duty to defend and will pay for that defense. At some point, especially if there's statutory vicarious liability, pretty unlikely, it sounds like, that the general is going to get out from under that unless the sub is found to be not negligent in some way. But one of the reasons for having insurance is so that that defense cost is covered by the insurance company and not by the covered entity, right? So I don't have any problem, putting the duty to defend on the party that could potentially ultimately be liable, whether it's vicarious liability or, look, if I'm a plaintiff, if I'm the injured party, I'm suing everyone I think I can bring in on it. Mm-hmm. So that's going to mean every sub that I think might have had a piece of causing the damage, and it's going to include the general contractor because of the statutory liability, and I might make a claim that they somehow negligently brought in an incompetent subcontractor. The same way employers that don't do a good background check bring in a child abuser to work in a daycare. I'm going to sue, I'm going to sue them for failure to properly screen or failure to properly supervise if they hire someone that's got violent tendencies into a workplace where that's going to be a risk. So Same thing here. You sue them and then you sort it out as the lawsuit goes through, and everyone's got to defend themselves in the course of the lawsuit. That's just a risk of operating in the business world, it seems to me. So as to the project-specific insurance component, you know, at some point, people are going to have to insure their own liability. And it just seems to me untenable to require for a general contractor to require a sub to have project-specific insurance to cover what might be general contractor ultimate liability. And if there's some language that can split the hairs here in a fair manner, I haven't seen it yet in the last 10 years. I'm open to it. But as already indicated, I was in the middle of these negotiations back when Senator Metzen chaired the Commerce Committee, and this is going quite a ways back. There's been plenty of time to try to figure this out, and if we don't have language yet, I'm interested in moving this forward. But you know, ultimately, it's up to the chief author what she'd like to do with the bill and how she'd like to handle that. Senator McEwen.
Thank you, Mr. Chair. And when you had stepped out briefly and the vice chair was chairing briefly, I had indicated to the members that I would appreciate an opportunity for my expert, Mr. Leo Halloran, to be able to respond to some of the discussion if that would be helpful for the members. And we also have a representative here from MnDOT who may be able to offer a little bit more information in regard to public owners. But I know, again, that the committee has a lot on its plate today. I just wanted to offer that up.
Sure. Well, I'd be interested in hearing both of those testifiers' responses, but not for 30 minutes. So why don't we ask the two testifiers at the table to have a seat back in the audience, ask Mr. Leo Halloran and our MnDOT representative to come forward, see if you can be concise in responding to the issues that have been raised here. And then if there isn't any further discussion, we'll see what the chief author wants to do with the bill. Which of the two of you would like to go first?
Go ahead.
Okay. Go ahead and state your name for the record and proceed.
Good morning, Mr. Chair and committee members. My name is Jim County, and I'm Deputy Chief Counsel at MnDOT, and I work with our contracting programs. I want to speak just very briefly about the A1 amendment, and I want to just kind of start with the premise that MnDOT, in our contract with our prime contractors, we don't require our prime contractor to defend or indemnify MnDOT for MnDOT's own negligence. So our contract provision says they have to defend and indemnify us for their negligence, the negligence of their subs, et cetera. So the A1 amendment that Senator McEwen authored this morning, I believe harmonizes with the MnDOT contract in that, you know, when we look at a project, we establish insurance requirements. Could be commercial general liability, you know, could be pollution liability, could even be marine liability insurance. We put our insurance requirements in place and we impose those insurance requirements on our general contractor. I think that's, you know, pretty easy to understand, of course. I'll qualify a little bit because, you know, then the general contractor and the subcontractors, you know, the general contractor pushes certain insurance requirements down to subs, and that's not my area of expertise, so I just want to make clear that I'm not really speaking about that. But as between a public owner and a general contractor, I think the A1 insurance language would actually kind of harmonize with what is in MnDOT's contract, and I also believe the Department of Administration's contract. And are there maybe subtle wording changes that we could think about? Yeah, maybe, but I think the gist of the amendment for me is that it kind of harmonizes the statutory language with what's existing in our contract provisions already. Thank you, Mr. Chairman.
Thank you, Mr. Crowney. Mr. Leo Halloran, anything to add here?
Yes, I can be brief as well because I do think Chair Latz and Senator Kroon's comments have been fairly well taken. I think a lot of what the testimony has been with regard to the A1 amendment saying that it wouldn't get you down the chain of contracting. I don't think that's true, remembering that the A1 amendment is sort of comfort language. The whole point is we're in a world where you can still require your subcontractor to have insurance for its own fault or negligence. So you can require your subcontractor to take on extra project-specific insurance for pollution liabilities with higher limits or whatever. They just can't be required to indemnify you, the general, or to indemnify and defend you, the general, in that situation. And I also think a lot of the commentary about, well, what happens with the timing is, the chair was correct. I think it would be sort of the only situation where the American rule doesn't just require people to handle it on their own. And, the timing is the timing of every duty to defend in every lawsuit. But in the background, again, you can require all of the subs to have insurance for their own negligence, and that insurance will come with an insurer who has an obligation under Minnesota law to defend you if there is a claim arguably within the policy. What we're trying to get rid of are these overbroad contractual risk-shifting agreements that that basically make the subs a second insurer for everybody on the project. We don't want to shift all the risk to them. They don't have the ability to sell premiums and shift risk. That's the insurance business's role on these projects. So just as a policy matter, that's why we want to make sure that you have the ability. You can have somebody who's responsible for their own fault. You can require them to insure, to obtain insurance that reaches their own fault. They're just not your insurance company. They're your subcontractor. And I think one last thing about the A1 amendment was on that chain of contracting issue, if the parties wanted to try and work out that last issue, there's actually language in the bill we could use. Page 2, line 2.3 talks about duties of the promisor or the promisor's independent contractors, agents, employees, or delegatees. We could make a similar change to this promisor's negligent acts or omissions, or the negligent acts or omissions of the promisor's independent contractors, agents, employees, or delegatees. If we wanted to make it crystal clear that we can allow those obligations to go down the chain of contracting. And one other thing, there was a mention of OSIPs and CSIPs. I think OSIPs and CSIPs are also currently specifically allowed by the provision that is in the A1 amendment, as always was allowed under the existing law.
Mr. Halloran, attest. State out the full name of the OSIPs and PRESIPs. What are they?
Owner-controlled insurance programs and contractor-controlled insurance programs. That's where you buy one policy for the whole project.
Okay, and so I have comfort in understanding, because I was sympathetic to the idea of maybe there's an unusual risk in a specific project that ought to be insured. But as long as I'm satisfied that there is still the ability for a contractor to require a subcontractor to have higher insurance or greater insurance coverage for the subcontractor's own negligence, then that would have the effect of protecting the contractor from undue vicarious liability exposure from their sub's negligence. So I think that's a fair, as long as that's the case, I'm very comfortable with this. But I'd be inclined to add the clarifying language that Mr. Leo Halloran just suggested to answer the question that was under discussion here about going down the tiers. Senator McEwen, what do you think?
I'm happy with that, Mr. Chair. I think that if we can provide just that extra ounce of comfort and clarity, then let's do it. But that said, Mr. Chair, after we make this change, I also just want to note for the record that a lot of work has gone into this language, to the work overall in a bill like this over years, as you have noted, and after we make that small change, I would like to see the bill move forward.
All right, so I'm going to ask counsel. So Ms. Primo, our civil counsel, is joining us remotely, and she's the one who's going to sort of make sure the language works for the amendment. So if Mr. Leo Halloran could restate exactly what language he wants to have added from line, looks like 2.2 and 2.3 of the original bill, and where he would recommend it be inserted. I assume using the language from the A1 amendment as the reference point. Mr. Leo Halloran.
Yeah, I think, 2.11 to 2.11 to 2.13 has been supplanted by the A1 amendment at 1.3 to 1.7. And so at the end of line 1.7 before the period, we would just add, or the negligent acts or omissions of one of promisors, apostrophe S, independent contractors, comma, agents, comma, employees, comma, or delegatees, excuse me.
Okay, so could you repeat that slowly one more time?
Or the negligent acts or omissions of one of promisors, independent contractors, agents, employees, or delegatees.
And Mr. Leo Halloran, would you add that language anywhere else as well? Is line, I'm asking, I don't know, 1.11
Yeah, I think I'm
similarly?
just want to check where that, I believe you would, yes. That would go, so that was line 3.4 on the original bill, which has now been supplanted by the last 3 lines of the A1 amendment. At the end of that A1 amendment, you could add the same added language.
So on line 1.11 after omissions, insert, and then the same language
insert
that you just
Yeah.
noted. All right, Ms. Primo, do you agree with this being the proper language for the amendment? Or do you have any suggestions to fix it, change it?
Mr. Chair and members, I just want to clarify 1.7 and 1.11 after emissions on the A1 amendment, then you would add that whole phrase or the negligent acts. I think that works. Those are the 2 places. Yep.
All right, is there, Senator Seeberger, will you offer that amendment?
So moved.
Is there any committee discussion on this amendment? Senator McEwen's already indicated she concurs with this, considers it to be friendly. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Is there any further discussion on Senate File 754 as amended? Any closing comments, Senator McEwen?
Only to thank all of you, Mr. Chair, members, for hearing this bill today. And this is just a basic fairness sense that everyone should be defending their own selves in construction contracts and not shifting risk and burden. So thank you.
Senator Seeberger, would you be willing to make the motion on the bill?
Thank you, Mr. Chair. I move that Senate File Number 754, as amended, be approved and referred to Finance.
Senator Seeberger moves that Senate File 754 as amended be recommended to pass and be re-referred to the Senate Finance Committee. All those in favor say aye. Aye. Opposed? Motion prevails.
Thank you very much.
Thank you, Senator McEwen and members. Okay, Senator Limmer, your testifiers are here and ready to go. Can we take your next 3 bills up? All right. We're going to start with Senate File 814, relating to forfeitures. And members, the materials are being distributed to you. All 3 of your bills are in the folder that you're receiving at this time. Actually, you know what? Before we get Senator Limmer's bill, we're going to just circle back to take the some action that we postponed before on Senator Pappas' Senate File 2798 involving the Minneapolis Police Department appointments. I did confer with Senator Murphy, who chairs the State and Local Government Committee, which is the only other committee that would have had jurisdiction over this bill. She has indicated directly to me that that committee is waiving its jurisdiction in connection with this bill. So the appropriate motion would be for Senator Pappas to move that Senate File 2798 as amended be recommended to pass and be sent to the Senate floor.
So moved.
All right. Is there any further discussion on that? Not seeing any. All in favor say aye. Aye. Opposed? Motion prevails. Thank you, members. Senator Limmer, to your bill on forfeitures, Senate File 814.
Thank you, Mr. Chair. This is a technical cleanup bill from 2021. It was attempted to be written and passed last year in 22, but despite the fact that the House and Senate were moving in the direction of accepting it, the session basically ran out of time. And so we have it now before us. Since the forfeiture changes went into effect in 2021, the courts have had a conflict between court rules and different statutes for what is appropriate service of process, service of process in conciliation court. This bill cleans up the confusion and provides consistency with adequate methods of notifying parties. There's two additions from the previous legislation. The reviser flagged a portion of it. A cross-reference needs to be deleted on lines 3.25 and 3.26. And the second one was a repealer. State Statute 504B.305 is repealed in the bill because it requires landlords to give notice that seizure could be grounds for eviction, only that's no longer a law, so there's no reason to give notice. So, Mr. Chairman, as I said, it's technical in nature. I'll stand for any questions if there are any, and I may have to rely on counsel for answering any more questions on this bill.
Senator Limmer, I have directly run into this conflict in my practice, and it's a real pain in the neck for the parties, and in one particular case, for the judge to figure out what was required, what wasn't. A lot of administrative running around late in the game to make sure all the dots, the I's were dotted and the T's crossed. So this is a good cleanup, and especially in the era of electronic service, now requiring service by mail. It was an extra expense and burden on everyone involved. So where conciliation court rules permit it, it could be handled electronically as well. Do you have any testifiers, Senator Limmer, or
I don't believe
just you?
I do on this bill.
Okay. Any members of the committee have questions relating to this bill? Not seeing any questions or discussion. Any members of the public? No hands going up, no one coming forward. Senator Limmer moves that Senate File 814 be recommended to pass. Where's it go? And be sent to the Senate floor.
So moved, Mr. Chair.
All those in favor say aye.
Aye.
Aye. Opposed, motion prevails. Thank you, Senator Limmer. Your next bill before us, Senate File 1198 on body-worn cameras. Senator Limmer, members, that's also in your packet. There is an amendment. It's an A1 amendment. It is an author's amendment, as this is the first committee stop for the bill. Senator Limmer moves adoption of the A1 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted. Senator Limmer, to your bill.
Thank you, Mr. Chair. This bill creates a grant program. It'll be administered by the Department of Public Safety to provide body cameras for law enforcement agencies across the state, giving priority to applicants that do not currently have a body camera program and to applicants that employ less than 50 licensed police officers. Each grant is contingent upon a local match of at least 25% from non-state funds. This program is important because it's widely believed technology can help increase transparency and rebuild trust among communities and police agencies. I'd also like to thank Senator Latz and Senator McEwen for joining me in this bill as co-authors. One of the reasons that we found this need is that small police agencies, smaller towns, simply do not have the financial resources to employ body cameras. This was part of our bill last year, but as we all know, that never came to fruition. So we're going back and encouraging local police agencies to avail themselves of a program like this. I have Jeff Potts from the Chiefs of Police somewhere in the room or on Zoom, and he can certainly give a brief testimony as well. Oh, he is here.
He was approaching behind you, Senator Limmer, which is something you never do to a police officer.
That's right.
Sorry about that, Senator.
Sneaky.
Former Chief Director Potts, go ahead.
Mr. Chair, thank you for allowing me to be here today. We want to thank Senator Limmer, rest of the committee for hearing this bill. I am here supporting or representing the Minnesota Chiefs Association as well as the Minnesota Sheriff's Association. We're very appreciative of this appropriation. Just a little bit of data. About 50% of the police departments, which there is about 315 police departments, not including sheriff's offices and some state agencies, are fewer than 10 officers. So we appreciate the priority in helping the smaller agencies. As the Senator Limmer mentioned, these are very expensive programs, and cost is definitely a barrier. We do definitely agree that body cameras can be a great tool for transparency and training within the agency, and any funds that will help us kind of close the gap on body camera programs across the state is very much appreciated. Our last survey, which was about 18 months ago, showed that there's still about 50% of the police departments in Minnesota that don't have body camera programs. So with that, Mr. Chair, Senator Limmer, thank you for this. We stand in support of this and very much appreciate the funds to acquire more body camera programs.
I've got a question probably for Director Potts. The grants, it states in the bill the money may be used for to purchase and maintain these devices. Does maintenance include managing the data that's generated, the recordings and so on, as well as redacting for individual cases when there's a release required, or does the maintenance basically mean keeping the devices themselves functioning?
Mr. Chair, my understanding is that that can be used to help cover the cost of the data, which becomes the largest cost for the agency after the acquisition. And so our understanding is that it can be used to help cover the data storage after the acquisition.
There isn't any limitations specified in the bill, so hence my question. I would assume the prioritization for giving the grants would be to getting the equipment into the departments first, and then
Mr. Chairman,
Senator
in
Limmer.
previous discussions, I always was of the mind that the money would also be used for data retaining. It may not be listed in the bill itself, but I certainly would include that. These small towns just don't have the ability to pay for the, let alone the equipment, let alone the recording of it and maintain it. Maintain meaning maintaining it for prosperity or for legal reasons. I certainly would add that if you think that it would be needed for clarification.
I would say probably the language would be helpful to clarify if that's the intent. I will also confess to a bit of concerned about going down that path. I can understand helping with initial investments for equipment, but for ongoing expenses relating to law enforcement operations, I think we're getting a little further into subsidizing local government costs than I'm comfortable, certainly on a long-term basis. And I understand it's the biggest expense for, in a lot of cases. Not only you're paying for storage, but at some point you're paying for the costs of some staff to go through and make at least statutorily required redactions in appropriate cases before the data is released to the public or released to the parties under certain circumstances to any dispute. So, but at some point, we've got local government aid that helps, local governments that don't have the resources to be able to pay for ongoing operational expenses. And there's a complicated formula for that. I'm a little worried that this might become a fund that would be turned to on a regular basis to cover those longer-term operational expenses rather than the initial equipment costs.
I don't.
Does anyone else share those concerns, or is it just my rumination that's here?
Mr. Chairman,
Senator Limmer.
could I ask Mr. Turner if he might know whether or not this is ongoing appropriation or is it a one-time?
Mr. Turner.
Yes, Mr. Chairman, the way we as the legislature, the practice is, if it's funded in the second year of the biennium, as we go into a full funded biennium, that means it's ongoing. It's only one time if it explicitly states this is a one-time appropriation. So this would be an ongoing appropriation.
Okay. Mr. Chairman, at least we could have that resolved, but the defining the purpose of the funds, you've raised an interesting question. Perhaps it might be best to take a first step in offering this program to smaller political subdivisions, and we can continue to work on it as this thing morphs a little bit after passage. We can keep it limited to the maintaining of the equipment itself and helping them achieve that equipment. I would be willing, my memory always was that it would continue on with retaining data. But this language does not include that. I haven't compared this bill with the previous language in the previous year. So I'm willing to accept the way it's written today. And as time progresses, we can discuss that later with cities that are using the equipment. I think they're really concerned about the first step of acquiring equipment.
So, Senator Limmer, being that the desire of the chief author, we are going to lay the bill over as it's a budget bill, and we're going to have a committee budget bill. I'm going to suggest that we continue to have some conversations, both in terms of whether this will be money for ongoing data maintenance and operation, as well as equipment acquisition. And then secondly, whether this is going to be one-time appropriation, or whether it's money that will go into a base. And maybe we can get some information going forward as to what the unmet need is also. If whatever the number is that we come up with in the end is going to be enough to equip most of the departments in the state with the basic equipment, it might not be even advisable or necessary to consider having it go into a base and be an ongoing appropriation.
Mr. Chair.
As everyone knows, there's more one-time money available in our budget this year than there is ongoing money. Senator Limmer.
Mr. Chair, what I'll do as we lay this over, I'll be in contact with the Commissioner of Public Safety They would be the ones administrating the grants. I'm sure they have a little bit more definition than what I'm available to today. And get back to you, and when we have clarity on it, we can consider it again.
Very good. Senator Uma Verbaeten.
Thank you, Mr. Chair. I agree with you, and I'm wondering if the and maintain language is necessary, if the intent is really to get this out to all of those departments that do not have these body cameras right now. And the bill does state that the priority should be given to those who don't have this already. So I think, getting that out to as many of our departments as possible and then seeing what needs they have after that would give us some time to bring in that maintain language.
There's also potential limiting language we could say to help defray the costs for the first year or 2 years of operation, and might reduce a barrier to a local government to taking on the responsibility of acquiring this, but then they could plan ahead to budget for the ongoing needs, especially as they learn what those ongoing needs might really look like in their own communities. So I can conceive of some limiting language that might smooth the transition here as well.
Mr. Chairman, just as added information, there are some towns that have very, very small police departments. Director Potts made mention of departments under 10. There's some that are just a few people, and their cities that they serve are equally small. And so we're trying to make sure that we create that adequate amount of transparency for all law enforcement, big and small, but the small ones just don't have the means to do it.
And I fully agree with that premise, Senator Limmer. Senator Uma Verbaeten.
Thank you, Mr. Chair and Senator Limmer. Just to follow up, and again, my concern is that, we get these out to those departments that don't have these body cameras right now before giving another department the opportunity to maintain some existing equipment, right? And that's sort of covered with the language here that says we should give priority to those who don't have it, but I want to get at that so that everyone has access first before we go into maintaining or updating equipment.
So noted.
Senator Kroon, did you have something to say? I wasn't sure if I saw a hand up or not. I don't want to. All right, then Senate File 1198 is laid over for possible inclusion in the budget bill. Next up on the agenda, Senate File 1199, Senator Limmer.
Thank you, Mr. Chairman.
And members, so you know, this will also be laid over for possible
Yeah,
inclusion.
Mr. Chairman, this is the Pathway to Policing Reimbursement Grant Program. And I do have author's amendment, the A1 amendment. It changes some dollar amounts.
Senator Limmer moves adoption of the A1 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Limmer.
Thank you, Mr. Chairman. We certainly have heard the news stories and discussions here in the state capitol about police recruitment and police retaining or retainage. It's a very real problem. And one of the programs that we have recognized in the past is Pathway to Policing. It's designed to bolster the law enforcement numbers by bringing new people into the mainstream of police profession. This proposal appropriates $1 million from the general fund to the Commissioner of Public Safety for reimbursement grants to local units of government that operate a Pathway to Policing program. Since Pathway to Policing is an existing reimbursement program, it has an annual base budget of $400,000. The new ongoing appropriation would be $900,000. Pathway to Policing programs are intended to bring persons with non-traditional backgrounds into law enforcement and provide a route for candidates who have at least an associate's degree in any discipline. Upon successful completion of a training program and passing the post-board exam, grantees are eligible for reimbursement for their training and education. Law enforcement agencies may apply for reimbursement grants to receive up to 50% of cost of compensating and training pathway to policing participants. This can be a very valuable thing for communities, and this may help people move into second careers as well and bring a fresh perspective into the whole profession of law enforcement. This bill limits the program to local units of government. However, Mr. Chair, there is an oral amendment that I wish to have the committee consider.
Director Potts, did you want to add anything?
Oh, Mr. Chair, I was offering an
I'm
oral
sorry.
amendment.
I was conferring with staff, and I missed your oral amendment. Senator Limmer, what is that amendment?
I don't know if Mr. Bagnoli is in the room.
Waiting anxiously to be
Waiting.
called to participate is Mr. Bagnoli. Come on forward.
Participate in another reelection bill. Yeah,
You got a number of them, Senator Limmer.
I'm on a roll. Thank you, Mr. Chairman. The oral amendment that I want us to consider, and I can explain it to you now.
Go ahead.
On line 1.7, after the word to, T-O, strike the words local units of government that operate and replace them with state and local law enforcement agencies that operate. The previous language was limiting, and this is opening it up a little bit, and Mr. Magnoli can explain the need for the new language.
Senator Limmer, are the last two words of your proposed amendment the words that operate?
That operate, correct.
So the stricken language does not need to include line 1.7, the words that operate, because they'll be repeated.
That's
So
correct.
It would just be strike local units of government and replace it with state and local law enforcement agencies.
Right, we could do that.
All right. And Mr. Bagnoli, you wish to explain the reasons for this amendment?
Mr. Chair, members of the committee, Joe Bagnoli with Winthrop and Weinstein Law Firm on behalf of the Metropolitan Airports Commission, and Mitch Killian is also here from the Airports Commission if I'm not sufficient. The Metropolitan Airports Commission is a very unique organization. It is a public corporation. It's one of two in the state. And public corporations have some of the powers of local government, but not all. It's the ones that the legislature has given them. The Metropolitan Airports Commission operates a police force and has participated in pathways. Police has participated and would like to participate in this program. The department has indicated to us that if it's restricted to local units of government, we do not qualify. They have not opposed this. In last year's bill, the 2022 omnibus, Senator Limmer's bill from last year, Judiciary Finance Bill, we had made this change, and subsequently, I think council has seen this change a couple times before in other bills where local units of government were used. It was changed to this to broaden it out to more fully get at least the airport in this particular place.
Any questions or discussions from members of the committee on Senator Limmer's proposed amendment? Senator Umu Verbatim.
Thank you, Mr. Chair. Senator Limmer, can you tell me what the definition is of persons with non-traditional backgrounds?
Senator Limmer.
Well, Mr. Chairman, might be better for Director Potts, but I'll take a stab at it. Non-traditional backgrounds. Right now, law enforcement is highly reliant on a law enforcement program or degree to qualify to become a police officer. And then after that formal training, then they go to the post board and get additional training and classification or licensure as a police officer. That the last part of that remains. Post board qualification is always necessary. But the beginning or the earlier education of an applicant has been grounded into this more formalized law enforcement program or education, often an Associate of Arts degree or perhaps a Bachelor of Arts degree in criminal justice or law enforcement. Pathway to Policing recognizes people coming from different either occupations that have not had that formal education but would like to become a police officer. And we're recognizing that in this program, and then they would go on to specific training and post-board qualification that's required by law. That's where the definition of non-traditional comes from. It's kind of in a narrow perspective. And Director Potts, have I missed anything in that?
I'll just, Mr. Chair, if I may just add just a little bit to what Senator Limmer was talking to. When this program was created back in 2017, we weren't in the recruitment and retention crisis that we are today, but we did recognize that the pool of candidates that we were drawing from was not very diverse. In my case, as the chief of Bloomington PD, we would oftentimes talk about trying to make sure we were doing whatever we could to make sure our police department matched in terms of demographics the community that we served. But the pool of candidates was not very diverse. So we intentionally created this program to be able to recruit in different areas that we were not able to at that time. You still need a 2 or 4 year degree, but it could be in any regional, it could be in any discipline as long as it's a regionally accredited college or university. And it definitely broadened our ability to recruit and bring in different candidates and folks to the police department that we were otherwise not able to do before this was a program.
Mr. Chair.
Senator Uma Verbatim.
Thank you, Mr. Chair. Thank you, Senator Limmer, Director Potts, and I certainly agree that we need to provide more of those opportunities for folks to pursue careers in law enforcement. In St. Paul, we have the Law Enforcement Career Path Academy, and one of the things that we track is the amount of women that are coming into the profession, the amount of people of color that are coming into the profession, because certainly in St. Paul, that's how we're going to get a department that better reflects the community, right, that they serve. And I think that's probably the most important piece, is trying to ensure that we have law enforcement that looks like the community, that comes from the community. I don't know if this language, non-traditional backgrounds, totally gets at that. That's a concern for me. I'm with you on the intent here, and I've seen, programs like the one I've mentioned in St. Paul. I know Roseville, my district, is doing a lot of work on this as well. But I think the key is really around trying to get law enforcement to reflect the communities they serve. And I would like to see our agency be tracking some information about women coming into the profession and people of color coming into the profession specifically. I don't know how much of that needs to be in the statute versus giving the department some kind of leeway on how they are handing out these grants, but I'd like to see more than just those with non-traditional backgrounds.
Mr. Chairman.
Senator Limmer.
I appreciate those comments, Senator. Quite honestly, I think this particular program, it's not going to cure the entire need, but it's certainly moving us in the right direction. And it's something that I think has long been needed to broaden just the backgrounds of our law enforcement officers. If we have a multi-source, let's call it, for lack of a better word, backgrounds in whether they're rural or urban, whether they're of different and diverse racial compositions, that's fine. I think that is something that we should continue to work on. This program is a little bit more narrower than that because it creates the financial program in order to promote this one element. And of course, it's going to be under the grant authority of the Commissioner of Public Safety. So, and we can keep working on it as well. Mr. Chairman, I don't remember if we made the decision on the oral amendment or not. Did we?
No, we have not taken action on that yet.
I'd like to renew that motion, Mr. Chair.
All right. Any further discussion on Senator Limmer's oral amendment? All those in favor say aye.
Aye.
Opposed? Motion prevails. Any further discussion on Senate File 1199? We adopted the A1 author's amendment at the very beginning. So not seeing any further discussion, Senate File 1199 as amended will be laid over for possible inclusion in the budget bill. Thank you, Senator Limmer. Going to Senator Carlson, I believe, at this time. We're going to go back to the closer to the beginning of the agenda. Senate File 1337, driver and vehicle services modifications. And Senator Carlson, if your witness, Mr. Zhang, is here, come on forward, Mr. Zhang, as well. Senator Carlson, when you are ready, go ahead and describe the bill that we have before us.
Thank you, Mr. Chair. Before us is Senate File 1337, and what it is an agency bill, and it has three major parts to it. It makes a specific crime to threaten a DVS employee engaged in the performance of their duties, and in the Elections Committee, it also added in the, I'm sorry, that was in the Transportation Committee, it added in the deputy registrars as well. It eliminates the knowledge test requirement for driver's license withdrawals due to certain insurance and drug offenses. This requirement was previously eliminated for DUIs. And there's a technical correction to add revoked to the category of individuals whose insurance violation history requires them to meet certified insurance requirements before they're enrolled in the, that's in the Ignition Interlock program. And with me to answer any questions and perhaps give some background on it is Mr. Pong Zhang, Director of Driver and Vehicle Services, Department of Public Safety.
Mr. Zhang, welcome to the committee. Go ahead and tell us why this is a good idea.
Thank you, Mr. Chair, and Pong Zhang, Director of the Driver and Vehicle Services Division. Thank you, Senator Carlson, for bringing this bill. This, like Senator Carlson already described, this has three major provisions. The first of which is it's a technical correction to the IIDP program, the Ignition Interlock program. And in 2021, there was a legislative change to require revocations due to insurance-related violations to meet certified insurance requirements under the IIDP program. Revocation was inadvertently left out, and this technical change would include it. The second section is to add a criminal offense to those who use force or threat of force on DVS employees in the course of their duties. We appreciate the amendment to add the deputy registrars and driver's license agents to that population. Over the pandemic, we've seen an increase in violent behavior, and this is just one more way we can deter that behavior. And then lastly, in the third section, this is to eliminate a knowledge test requirement to reinstate a credential or driver's license. In 2021, the requirement for a knowledge test to obtain a credential was eliminated for DUI offenders. This would repeal the need for knowledge tests for other convictions. Criminal offenses in this category are generally due to inability to enforce insurance, a substance use disorder, a substance use or reckless or negligent driving. The intent here is to make evidence or make our practices evidence-based. These revocations will still have all the other requirements in order for them to obtain their credential. And with that, I'm happy to stand for any questions. Thank you.
So, Mr. Zhang, I'm trying to determine with regard to the change in the criminal statute. This is an existing criminal statute that already makes a crime for obstruction of or interference with the duties of anyone serving legal process or attempting to apprehend someone on a criminal offense, peace officers while doing their official duties, firefighters, ambulance personnel, crew, Revenue Department employees, and the proposed addition then is Driver and Vehicle Services Division employees, a licensed driver's license agent or a deputy registrar while they're doing their duties. And so for me, the threshold question is whether or not DVS employees, license agents, or deputy registrars are at comparable risk and of comparable significance in their work, that they should be protected with a special potential criminal consequence like the other persons are in the statute. And then the second question is whether or not the penalties are appropriate. The penalty provision, members, is not reproduced in the bill because it's not changed. But for your reference, subdivision 2, which is referenced on line 3.13, it does provide for a 5-year felony if a risk of death, substantial bodily harm, or serious property damage was caused or actually caused those. So creating the risk of or actually causing death, substantial bodily harm, or serious property damage, whatever serious property damage is, it's not defined. It's a 5-year felony, or if it's accompanied by a force of violence or a threat of force of violence, it's a gross misdemeanor. All other cases of force or threat of force, and actually it would only be force or threat of force. There'd be no misdemeanor penalty here, because paragraph 5 that's amended would automatically fall within the gross misdemeanor penalty provision. So, Senator Howe, you have a...
Thank you, Mr. Chair. And I guess where my question comes into is I still have an issue with not requiring a test for those folks that commit vehicular manslaughter, vehicular homicide, that type of thing. If anybody should be going through a test, I believe it's those folks. I don't think we should just give them a license.
We are going to convene this hearing. Welcome, everyone. Today is Friday, March.
I don't think we should be giving those types of folks a free pass, because if anybody needs retraining, I think it's those folks. So that's where I believe that I have an issue with giving those people a free pass and a driver's license and retraining. So that's my only comment.
So, thank you. And just for the record, it sounds like you might be monitoring more than one activity at this time. So the background reference was, just for the record, it was not from anyone in the committee room here physically present. It was from your Zoom. Is that correct?
Yes, Mr. Chair.
I just want
Mr. Chair, that's the Transportation Committee I'm also on, so thank you.
Very good. We're glad that you are being efficient with government resources, Senator Howe. Mr. Zhang, what is your response to Senator Howe's concern about the value or importance of the driver's exam for reinstatement following a revocation from a CVH or a CVO? Mr. Zhang.
Mr. Chair and Senator Howe, the intent of this is to have evidence-based practices, and as we look at the efficiencies of our processes, we do not see the correlation between a knowledge deficit and those actions. And so the proposal is to remove the knowledge test requirement. All the other requirements to reobtain their credential are still all intact, just the removal of the knowledge test.
Mr. Zhang, what are those other requirements for reobtaining the driver's credentials?
Mr. Chair, I don't have those exact requirements in front of me. I am happy to prepare and share that with the committee.
So certainly there's the payment of the reinstatement fee, and there's the required proof of insurance in connection with the ignition interlock device. These are applying. This is under the interlock statute, so all these persons that are reinstated would only be reinstated with the interlock device required to be installed in their vehicle. The only vehicle they could lawfully drive is the one with the interlock device. The interlock device would prevent the ability to start the vehicle without blowing into the device and proving that there is no alcohol in the person's system, and then rolling retests to verify that while the driving is occurring, as well as a camera to verify the person behind the wheel is the person that started the vehicle as the person subject to the requirement, because all that information is on record with driver and vehicle services. I know that from my own personal knowledge, but it is, I don't know if there are any other specific requirements, but you've indicated that there isn't a correlation between the knowledge exam and driving conduct, at least as to these individuals. Is that right, Mr. Zhang?
Mr. Chair, that is correct. The knowledge test that is currently required is the same knowledge test that is used for someone who's trying to obtain their driver's license for the first time. It's the exact same test that is provided in that situation.
So the people who are going through this situation, at least for the interlock requirements, interlock is not a way to get your driving privileges back anyway for criminal vehicular homicide cases. That's correct, Mr. Zhang, right?
Mr. Chair, that is correct, and I believe Senator Howe was referencing the Section 3, which is the knowledge test required for other convictions, including DUI convictions.
And for criminal vehicular operation, but non-homicide related cases, I believe you, I'm going to double check this, I'm working from memory here, but honestly, I don't recall whether or not you can get your license back with the interlock, at least for the alcohol-related CVOs. Maybe council can take a quick look and verify whether that's the case. But in any case, we're talking about alcohol-related interlock-related license reinstatements anyway. So all the people that would go through this process, exam or no exam, would only be able to drive lawfully in an interlock-installed vehicle, right?
That is correct, Mr. Chair.
Okay, so then the question is, would this exam add anything of value to protecting the public based on that? The reason they're there in the first place is because they were driving drunk. So I kind of doubt whether or not passing a written exam is going to affect anyone's ability to drive or safely under these circumstances. And certainly for people who have, well, if you're at the interlock stage, you are at least a first-time offender with a high test, .16 or more, or you're a repeat offender, and you are required to go through a chemical dependency evaluation as a consequence of the conviction anyway for those offenses, and follow recommendations. That's a mandatory condition of sentencing on the criminal case. And on the license reinstatement, certainly if you're at the point of a cancellation and denial, which is a third offense or more within a 10-year period, you have to show that you're going through rehabilitation to get your license back, which includes treatment. So all of that would be far more robust than a written exam on a computer at the driver's license exam station. So I'm pretty comfortable that the added cost and administrative bureaucratic requirements for getting the additional written exam in there would not add anything of value to protect the public safety under the circumstances. I think certainly if you're at a CVO stage, you've got the same robust requirements. All right. So is there any other testimony? I'll ask anyone in the public wish to testify in connection with this. Any further discussion from members of the committee? That's right. All right, Senator Carlson, we've been advised that the Transportation Committee would like this returned to them, where I think they are going to perhaps incorporate it into some other legislation that they're working on. So at this point, Senator Carlson moves that Senate File 1337 be recommended to pass and be re-referred to the Senate Committee on Transportation. All those in favor say aye.
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 Opposed? The motion prevails.
Thank you, Mr. Chair and members.
Senator Carlson. So, members, as I had explained at the last committee hearing, anticipating our schedule for today, the plan was to take a break between 2 and 4 o'clock p.m. to facilitate members' needs to attend other committees. But I don't want to be in a position, if we can avoid it, where we've got 5 minutes or 30 minutes worth of hearings left, and we have to come back 2 hours later to finish off a small agenda. So we've kind of done an informal survey of members' schedules, and it seems like there's a consensus that if we can maybe run a little bit past 2 o'clock now, we could potentially avoid the need to return after 4 o'clock. If we have, a need to do that because we've got, a meaningful, lengthy agenda left after 4 o'clock, we'll do that. But if we can get our stuff done now, then we won't have to return. So, members, what we're going to do now is take up the next item on the agenda, not 1602. We're going to go to Senate File 1941, and we're going to give the gavel over to Vice Chair Umu Verbaeten, because the next two bills are mine. And Colonel Langer, you're the witness on Senate File 1941. If you'd come on forward, we'll get that going.
Senator, good. It's good to see you. Yeah, you too. We'll put you back on track here.
Thank you.
Senator Latz, we have Senate File 1941 before us, and you have an author's amendment. Would you like to begin with that?
I do. Members, I move the A1 amendment.
Okay, Senator Latz moves the A1 amendment. All those in favor, say aye.
Aye.
Any opposed? Okay, the amendment's adopted. To the bill.
Thank you, Madam Chair. Senate File 1941 expands the ability of the use of preliminary screening tests or breath tests in certain proceedings. This is a bill initiated by the State Patrol so that they can utilize these devices roadside to detect the presence of alcohol in certain commercial driving-related inquiries. I have with me Colonel Langer, who leads our State Patrol, to explain that in more detail.
Colonel Langer, if you could state your name and title for the record and then begin.
Madam Chair, members of the committee, my name is Matt Langer. I have the honor and privilege of serving as Chief of the Minnesota State Patrol. And very simply what this bill does is it just allows law enforcement officers to use the preliminary screening test, the PBT, in cases where we suspect a driver of a commercial vehicle may have been drinking or had consumed alcohol, but is not impaired sufficient to the degree that they'd be arrested for impaired driving. So the 0.04 is the per se limit that indicates impairment for commercial motor vehicle operators with CDLs. But what we're talking about here is a case where someone might have a detectable presence of alcohol in their system. And ironically, the Minnesota state law does not explicitly allow the PBT to be used in that purpose. So we believe this is good check and balance. If one of our troopers, for example, stops a commercial motor vehicle driver and they detect alcohol, that the PBT will in fact confirm whether that detection that they're seeing is accurate or not. And if it's not, that driver goes on their way. And if they indeed have some detectable presence of alcohol, then they're put out of service for 24 hours, which is the federal regulation. So all of that is to say it would be treated very similar to a school bus driver, which is an admissible use in state law.
Senator Latz?
Madam Chair, the other element of the bill is that it would allow the results then of the preliminary screening test to be used in the criminal prosecution for a violation of the Code of Federal Regulations, federal statute that are incorporated into Minnesota statute. I'll refer you to lines 2.4 and 2.5 in the bill as well, which are the ones that are cross-referenced in the A1 amendment also. The preliminary screening test is very good at detecting the presence of alcohol, but it's not so good at detecting specific levels of alcohol in the system. So the use of these preliminary screening tests in our statutes have been limited to probable cause determinations when making an arrest for DWI, for example, but then the more sophisticated and reliable data master breath test instrument back at the police station, which has been rigorously tested and approved, is the only one that can be used as an element of proof to prove someone actually was, for example, a .08 or above. The presence requirement, however, is the only thing that would be allowed for the preliminary screening test under this bill here for the identified offenses.
Members, do you have any questions? Okay. Senator Latz?
Then where does this go? Let's keep this moving. I move the Senate File 1941 as amended be recommended to pass and be sent to the Senate floor.
All right. Senator Latz recommends that Senate File 1941 be recommended to pass and referred to the Senate floor. All those in favor say aye. Oh, I'm sorry, as amended. Aye. Thank you. Any opposed? Oh, it is moving to the floor. And we'll move to your next bill, Senator Latz. Did you want to do 1602 or 1586?
1602, please.
All right. Whenever you're ready.
Madam Chair, Senate File 1602 makes a couple of amendments to the state's ignition interlock provisions. And also, and also to the conditional release provisions in statute. So to set the table for this, If a person is arrested on suspicion of a gross misdemeanor driving while impaired offense, meaning first-time offense of .16 or higher test or a repeat offense, they are held over, they're not released immediately from jail, typically. They are held over for appearance in front of a judge. And there are certain mandatory conditions for their release that are set forth in statute. The two conditions, basically, either they post bail in the amount of $12,000, which can be cash or bond, and if they meet that, that's the only thing they have to meet, except to promise to return to court, and there aren't any other conditions applied to their release. Or they are required to be given the option by the judge of being released from court, but with the condition that they abstain from alcohol and be subject to electronic alcohol monitoring. These are also the same releasees that, if they wish to drive lawfully following the administrative license revocation under the implied consent law, can only do so by installing the ignition interlock device in their car and driving only that vehicle that has the interlock device in it. Since one of the conditions of the interlock program is that they test basically once a day, or they use their vehicle at least once a day to maintain the requirements within the interlock program itself, which means they're being tested at least daily and probably multiple times daily if they're driving their vehicle to and from work or other obligations that people use their cars for. So it seems to be redundant that they would be tested for alcohol abstinence to start their vehicle and use their vehicle, and also have to carry with them a separate alcohol monitoring device that verifies their abstinence. So what this bill does is it authorizes the judge at the time of release or any time during their conditional release while the criminal case is pending to change the conditions to allow the use of the interlock device as the abstinence verification method while they're released pending resolution of the criminal case. And in lieu of that alcohol, a portable alcohol monitor that is currently in use. So the subdivision 3 on page 2 indicates that the court is not required to do this, but they do have the option of doing it. So that is paragraph A under subdivision 3, which is added on line 2.17. The other provision of this bill addresses a different situation, but also related to ignition interlock. There are some counties that have contracts with specific interlock providers and direct, formally or informally, individuals who are in this situation to utilize that particular vendor, including where the county is subventing the cost of installing the interlock device for indigent persons, as is currently allowed under statute. Sometimes it's come to our attention, sometimes staff are, even when there's not a contract, they are, steering would be the more abrasive term to use perhaps, but sometimes perhaps not inaccurately, but at least suggesting that certain vendors be the ones to whom a releasee or potential releasee, someone who's in custody, if they want to get the interlock device, that they go to that particular vendor. There are 6 or 7 authorized vendors in the state of Minnesota, and I personally think it's inappropriate for public employees to be suggesting any particular vendor to a person that is going to be going to get the interlock device. So it has also had the effect, I believe, of freezing out or making it, or at least disadvantaging every other vendor that doesn't receive the recommendation or suggestion from being able to compete for the same business in that particular county or location. So in order to level the playing field, this bill also states, starting on line 2.24, that a judicial officer, county agency, or probation office, and by inference their employees, may not require or suggest that a person use a particular vendor when complying with the subdivision, but may provide a list of all the authorized vendors in Minnesota to the person. So they know who they could call, but they can't be told that they should call this or that vendor in particular. There is an exception in there for counties where there's already a contract for a specific vendor for indigent participants. In other words, a person could be notified if they're going to qualify for indigent financial support that this one particular vendor is the one that is contracted for by the county, so they could do that. And then if you turn to the final page of the bill, section 2, it basically mimics that language in a different provision, in a separate choice of vendor provision as well. So both when someone is released from custody and at any other later point, it would provide steering any potential interlock program client toward any particular vendor, except in the case of an indigent situation where they're going to participate in that program. With that, members, oh, and I will explain the A1 amendment as well, which addresses a different problem. And members, this was part of a broader DWI package that was proposed a number of years ago. And to understand this, you have to understand that when there is a DWI situation that involves a plate impoundment, this is again a first offender, 0.16 or more, or a repeat offender, current statute provides that the plates that are subject to the impoundment order are the plates on the vehicle that was used in the commission of the offense, as well as every other vehicle that accused offender is a registered owner of, whether they are the sole registered owner or they are the co-registered owner, which is often the case when you have couples that are getting loans and the lending agency that's going to provide the funds to purchase a vehicle want co-signers. So then the co-signers, the spouse, ends up on the vehicle as well. And when you get a plate impoundment and you get you want to get the vehicle back on the road, you often have to get special series plates, sometimes called DWI plates or whiskey plates, so that the entire world knows that the driver of that vehicle or someone associated with the ownership of that vehicle at some point got a DWI that required plate impoundment, even if they're not the one actually driving the vehicle. Could be a spouse, could be a child, could be a friend to whom the vehicle was loaned. So it's already the law that just having a special series plate is not probable cause to pull a vehicle over for suspicion of DWI. It might catch a law enforcement officer's attention and they might watch the vehicle a little more closely, but they can't just pull the vehicle over because of the existence of those plates. And then the connection to who the actual driver of that vehicle might be is increasingly tenuous when you consider who else might have access to that vehicle. And by the way, this includes almost all vehicles, so it applies to ATVs, it applies to boats, it applies to trailers that get license plates as well. So it's way overbroad, and then, so what you can see from the statute, basically, it just deletes all of the expanded universe and just says the impoundment order applies only to the vehicle involved in the plate impoundment violation. So I've laid a substantial base, members, but these kinds of issues I know sometimes raise questions beyond the specifics of the bill that is being presented, so I wanted to lay that foundation. I'm happy to answer any questions, and I ask for your support.
Thank you, Senator Latz, and I'll take it that you've moved the A1 amendment, which is an author's amendment. All those in favor say aye.
Aye.
Any opposed? Okay. The amendment's adopted. Members, do you have any questions or comments? Senator Limmer.
Thank you, Madam Chair. Senator Latz, with the passage of the A1 amendment, if it became law, does this get rid of those specially designated plates, the whiskey plates?
Senator Latz.
Madam Chair, Senator Limmer, no, it would eliminate the need to get them for all of these sort of ancillary vehicles that are involved. But there's a separate law that provides for the special plate requirement. If a person reinstates their driving privileges under certain circumstances and they want plates back on the vehicle, there actually is a provision in the interlock statute that provides that if they get the interlock, then they can get, if they're willing to pay the extra cost, they can get regular plates back instead of special series plates. But if they don't want to pay the additional $100 to do that, they can get the special series plates along with the interlock.
Senator Limmer.
Thank you, Madam Chair. Senator Latz, I'm glad you brought this bill forward, or the series of these bills forward. The discussion of whiskey plates, I just want to take a brief moment. I really consider those a scarlet letter. And quite honestly, I don't see why we need scarlet letters in the treatment of people that are addicted to a compound. I know that your legislation isn't going to go in that direction, but even when my children were little, driving around in a car, all the little kids know what a whiskey plate is. And they point at it, "Look, Dad." And I can only imagine the embarrassment in certain communities in Minnesota where every little kid knows that your mom or dad has some kind of problem. And I just don't see why we even have those plates. If it doesn't give a special grant or authority to a law enforcement officer to pull them over, I don't understand why we have them. So I'm just making that point clear. The other question I did have is, in the event that someone violated the proposals that you've outlined, what's the consequence to someone who drives another car drunk or under the influence? What happens to that person if they can't stay on track on the program with a breathalyzer?
Senator Latz.
Madam Chair, Senator Limmer, it is a crime to, if you are required to drive only a vehicle with interlock and you drive a different vehicle not installed with interlock, that is a crime in and of itself. It would also disqualify you from participating in the interlock program. If you drive drunk, then of course you're still subject to the regular DWI statutes.
Okay.
To augment your first comment, though, imagine if you are the spouse of a person who got a DWI and they've installed interlock in the offender's vehicle, but you're the spouse driving around a vehicle that's not required to have interlock but does have whiskey plates on it, and you use that vehicle to drive other friends or families or neighbors' kids to and from sporting events or activities, or you use it as a part of your business and you're driving clients or go to and from client meetings, and not only you're bearing then the scarlet letter of your spouse's conduct and not your own. It's even more embarrassing or worse.
Senator Limmer?
Thank you. I'm pretty much done, but maybe we can work on that other project sometime soon. Perhaps getting rid of the scarlet letter on a license plate.
Altogether.
Senator
Glad to
Latz.
work with you, Senator Limmer. Thank you, Madam Chair.
Any other questions, comments? Senator Latz?
Madam Chair, I'm going to ask that we lay Senate File 1602 over so that we have it available if we need it to be able to move along other aspects of our committee's work.
Okay. Senate File 1602, as amended, is laid over. Senator Latz, we have some testifiers here for Senator Seeberger's bill, so I'm wondering if we can go to that next.
Absolutely. Senate File 1576. We have one amendment in the packet. This is your first committee stop, so Senator Seeberger moves adoption of the A2 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. Amendment's adopted. Senator Seeberger, to your bill.
Thank you, Mr. Chair, members of the committee. This is a bill that establishes a grant for public safety agencies for radio communication. My amendment significantly alters the amount requested, and I'll tell you why. So the cost of the bill as introduced, the $250 million, represents the total need across the state of Minnesota for this money. However, as originally drafted last year, this bill was trying to take advantage of federal funds through the State Fiscal Recovery Federal Fund to the Commissioner of Public Safety, but that fund is no longer in existence. So my amendment seeks the dollars from the general fund, reduced to a $5 million request, just to get this program up and running and start addressing the needs that exist today. Setting into place this capital program will assist our volunteer fire departments, our EMS and law enforcement members in our communities to purchase the communication tools they need to connect and communicate safely and swiftly, arrive on scene, and be ready to assist our residents in the time of need. This bill is structured to have the Department of Public Safety create a fund with the resources we allocate and distribute grants to local government units, federally recognized tribal entities, and state agencies participating in the statewide Allied Radio Matrix for Emergency Response, otherwise known as the ARMOR program. The grants must be used to purchase or upgrade portable radios, mobile radios, and related equipment. We ask for a 5% match from non-state funds to bring in fiscal partnership. And I'm going to tell you briefly how important radios that work are. As I've brought up, I think, several times, I'm a paramedic. I am out on the streets on an ambulance. When I'm outside of my truck, I rely on my radio to be able to communicate not only with my partner, but with dispatch, law enforcement, anybody else who I might need when I'm on the scene. If my radio isn't working, I'm out there blind. We have a system here in the state of Minnesota that ensures interconnectivity between radios when we need that, and that is the ARMOR system. As agencies upgrade their radios and their equipment, portables are expensive. I want to say the typical portable Motorola radio that I wear on my belt as a paramedic is upwards of $15,000 per unit. So they're not cheap, but they are lifelines for folks who are out in the field, police officers, paramedics like myself, and fire. So I have testifiers today to help share the importance of this, to explain a little bit more about the armor system. And Mr. Chair, when you're ready, we can hear from them? Okay.
Come on forward to the testifier table. Mr. Schmidt, welcome to the Judiciary Committee. Go ahead and identify yourself for the record, state your affiliation, and proceed with your testimony.
All right, good afternoon, Chair Latz, members of the committee. I'm Steve Schmidt, I'm Meeker County Commissioner. I'm Chair of the Association of Minnesota Counties Public Safety Policy Committee. And my further personal involvement includes I'm the Vice Chair of the Central Minnesota Emergency Services Board. I am the Emergency Management Director for the City of Eden Valley. I'm the Eden Valley Fire Department Safety Officer. I'm the Eden Valley Rescue Squad Training Officer. AMC strongly supports Senate File 1576, which provides funding to replace the armor radios throughout the state. Minnesota's emergency preparedness system has been funded primarily by inconsistent federal sources over the years. Supportive and effective state funds are an immediate need for this critical function of emergency services related to the Allied Radio Matrix emergency response or the armor radio system. 911 telecommunication service fee can be utilized for costs related to the 911 system. However, federal rules do not allow these funds to be used for armor maintenance or equipment outside of the dispatch center, and that's where our current deficiencies lie. Thousands of radios in Minnesota are outdated and need of replacement and can cost upwards of anywhere from $6,000 to $15,000 depending on the agency. That's each. Further critical support systems such as the repeaters and towers haven't been able to keep pace with our ever-advancing technology. Armor, our AMC, and other stakeholders have identified a need of upwards of $250 million in funding to bring armor up to something recognizable of compliance. The extreme shortage of public safety personnel, coupled with the lacking communication system, has placed an additional strain on an already overburdened emergency response sector of our local governments. The armor system is critical to support the work of law enforcement, emergency management, firefighters, EMS, and other public safety officials. This legislation did not pass last year, increasing the urgency as our current systems continue to be strained even further. Couple this with the extreme shortage of first responder personnel and other critical components. This leaves first responders, as myself, highly concerned of the safety and operability of our response systems when imminent emergencies happen on any size or scale. In public safety, we are always concerned that we are not prepared in the event of an emergency or crisis. This critical infrastructure piece has us feeling as we have left the door wide open for trouble to walk through. The funding for this armor radios will help close that gap. Thank you to Senator Seeberger for authoring this bill and Chair Latz for hearing it in your committee. Replacing armor radios will help keep Minnesota counties safe, and we ask committee for support of this bill. I will open for questions.
Thank you, Mr. Schmidt. I'm also told we have Donna Greiner participating virtually. So Ms. Greiner from Big Stone County. Welcome to the committee.
Good afternoon. Dear Chair, Vice Chair, and members of the committee, thank you for hearing my testimony today. My name is Donna Greiner, and I'm the Stevens County and the Big Stone County Emergency Management Director. I also serve as the local armor system administrator for the Stevens County Sheriff, and I also serve on many regional committees. Armor is the backbone of public safety communication infrastructure in the state of Minnesota. It is a priority to ensure the emergency radios are up to date and able to provide interoperability for our EMS, first responders, firefighters, and law enforcement personnel. On July 25th, 2021, a 911 emergency call was made in the city of Clinton. The caller reported a large elevator fire. There were 19 fire departments and 17 other departments from multiple counties supporting the response over a 2-day period. All responding fire departments were able to communicate over the 800 megahertz Armor radio system. These departments have aging radios and are in desperate need of funding for replacement radios. Days after the incident, Governor Walz, Congresswoman Fishbach, Senator Westrom, and Representative Backer visited the location and heard from local emergency services departments. One of the fire chiefs who responded to the fire in Clinton explained his concern of how small departments are unable to replace aging radios. He explained that the money they bring in for fundraising is used to replace equipment that is needed to fight the fires. They also have a small tax base and their members are all volunteer. This funding will maintain interoperability for emergency response departments throughout the state of Minnesota, allow for emergency response departments who do not have adequate funding sources to replace aging or inoperable radios, allow departments that may have inadequate number of radios in their workforce to replace needed radios. This will improve their communication capabilities while enhancing responder safety when responding to a 911 call for help. The following points provide awareness of the immediate need for funding throughout the state of Minnesota. Radios purchased years ago have begun to reach the end of life, the end of support for products. Replacement parts for the aging radios are difficult to find or no longer available, and replacement of Armor radios range from, like they've said previously, $2,500, and I have up to $6,000 is what we use for repurchasing radios. And depending on the model and the need, it can go up to $5,000 or $15,000, like Senator Seeberger had mentioned. Many local government units can only provide funding through their levies. This is a direct impact to the local taxpayers and an increase to local levies. Small rural county emergency services departments do not have levy authority to fund radio replacements. And last year, we received numerous letters from throughout the state of Minnesota in support of this bill. And again, this year, we are receiving numerous letters in support and resolutions from county, cities, emergency services leaders, and associations. And I'm hopeful that we can look at the dollar amount that is needed. The $250 million that was requested last year was an estimated amount that we need. I'm just a little concerned about the $5 million not being enough. I thank you for your time, and I greatly appreciate Senator Seeberger for bringing this forward. And I appreciate the opportunity to represent our emergency services departments throughout the state of Minnesota. Thank you so much.
Mr. Chair?
Thank you. Thank you, Ms. Griner. Senator Seeberger.
At this point, I would like to lay this bill over to take testimony from a witness on my next bill who, as I understand it, is running short on time.
Will do. Senate File 1576 is laid over. I will now bring up Senate File 1989. Staff will distribute the committee packet to the members. Senator Seeberger, shall we go straight to your testifier and then you can explain the bill after that's concluded?
Yeah, that would be fine. Thank you.
All right. Katie Slifko is joining us virtually. Ms. Slifko, are you there with us?
I am. Thank you very much.
Yes, thank you for joining us on the Judiciary Committee today. Go ahead and present your testimony, please.
So I just want to thank everybody for allowing me to be here today and to give testimony on this. My name is Katie Slifko. I am the wife of Sergeant Corey Slifko, who actually died by suicide in 2019. He was a law enforcement officer with 20 years of service for the city of South St. Paul and was diagnosed with PTSD and had work-related injuries that ultimately caused his untimely death. And so this bill is very important to me and my family to give Corey the recognition and the honor that he deserves for his 20 years of service, dedicated service, that is, to the city of South St. Paul.
Ms. Slifko, do you have any further testimony you'd like to share with us today?
Well, I would just like to share the importance of this bill, like I said, to give honor and respect to those servicemen and women that have given their life for this career and protecting their communities and such. And having this bill go through to include suicide as in the line of duty is just a super important thing for my family and my children.
Thank you very much.
And I'll take questions if anybody has any for me personally.
Well, we are very sorry for the loss that your family has experienced here, and appreciate your taking the time to join us today. Any members of the committee have any questions for Ms. Slifko? I'm not seeing any, so thank you very much for participating in the Judiciary Committee.
Thank you so much, and thank you, Senator Seeberger, for bringing this bill forward for us. We so appreciate it.
It's my pleasure. Thank you.
Senator Seeberger, would you like to complete Senate File 1989, or would you like to return to the other bill?
Mr. Chair, my preference would be to return to the first bill and then spend a little time on 1989, whatever makes the most sense to the committee.
Let's do that then. Senate File 1989 is laid on the table. We'll take from the table Senate File 1576. Senator Seeberger, I guess I'll ask, is there anyone else in the room that wishes to testify in connection with the Public Safety Radio Communication System funding? I'm not seeing anyone. Any members of the committee have any questions or discussion relating to this bill? All right.
Mr. Chair?
Senator Howe.
You know, as a former emergency manager director and a former fire chief, I can't stress the importance of this bill. And I think it's woefully, I think we need for once, I'm going to agree that this is an important bill, but I think it's wholly inadequate for $5 million. So that's my pitch. Radios are wholly important for firefighters to talk to the police officers, to talk to the paramedics, as we have complicated scenes these days. So I support the $5 million, but I would hope that we can do better than that. And I'll leave it at that. Thank you, Mr. Chair.
Thank you, Senator Howe. I trust you will advocate for making more funds available for our Judiciary Public Safety budget as we are making our decisions here. Any other members of the committee wish to be heard in connection with Senate File 1576? Not seeing any. Senate File 1576 is laid over for possible inclusion in our budget bill. Take from the table Senate File 1989. Senator Seeberger.
Thank you, Mr. Chair, members of the committee. Before I get into too much discussion on Senate File 1989, I do have an author's amendment. It's the A1 amendment that I would move at this time.
Senator Seeberger moves adoption of the A1 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Seeberger.
Thank you, Mr. Chair, members of the committee. I am proud to be able to present this bill to you today. As you heard from Ms. Sivko, she's a constituent of mine, and this matter was brought to my attention when she approached me and told me that because her husband died by suicide, directly related to PTSD stemming from his job, he was not eligible for certain benefits that any other lost line of duty death would be available to them. Our first responders experience traumatic events while on the job. Some studies even show that 1 in 3 first responders will develop PTSD because of their job. This bill allows families to receive death and survivor benefits for public safety officers who die by suicide as a result of their jobs. This bill has been a part of negotiations in the past, and we hope we can get the support this year for our first responders and our families. As Ms. Sivko alluded to, or as she said, when her husband died by suicide, stemming from PTSD that resulted from his job, that only at that time did she discover that certain benefits weren't available to her. The nature of these jobs, being a police officer, being in fire, being a paramedic, you see things that the average person doesn't see. You're knee-deep in situations that the average person never experiences in their life, yet we see them daily. It's part of the job. If a person develops PTSD because of their job, and that PTSD ultimately takes their life in the form of suicide, there's no reason why this should not be considered a line of duty death, the same as any other line of duty death. I believe, do we, there, yep, okay. We also have Sheriff Scott Rose from Dodge County Sheriff's Office who can speak a little bit more in depth to this as well, Mr. Chair.
Sheriff Rose, appearing virtually today, welcome to the committee. Go ahead and state your name and your affiliation and proceed, please.
Thank you, Mr. Chair. I'm Sheriff Scott Rose. I'm the sheriff with the Dodge County Sheriff's Office.
Sheriff, if you have a microphone there or a device with a microphone, if you could get
Yep.
closer to it or speak up so we can hear you better, please.
Is this better?
Not much.
Let me just check one of my settings here. Okay, is this any better?
There we go. Thank you.
Okay. Sorry about that. I'm working from home today. Mr. Chair, I appreciate the opportunity to speak. I am the sheriff with the Dodge County Sheriff's Office. I've been in law enforcement for 25 years. I'm serving my third term as sheriff. In Dodge County, we're just west of Rochester. A little bit of my background, I'm on the board of directors with the Minnesota Law Enforcement Memorial Association. I'm on the board of directors for the Law Enforcement Memorial Foundation of Southeast Minnesota. I'm also on the executive board of directors for the Invisible Wounds Project. Mental health issues with law enforcement and first responders is very near and dear to me, as well as suicide prevention and suicide awareness for law enforcement. Regards to Corey Slifko, I knew Corey before he was an officer. I knew him right when he got out of college. In all honesty, I grew up 2 blocks away from Katie, his wife, in the same town in southeast Minnesota. And just to tell you a little bit about Corey, Corey was a sergeant for South St. Paul PD. And he was the kind of cop, he was kind of the stereotypical cop without being, how do I explain it? So he was the guy that worked his way up the ranks fast. He was a hard driver. He was on guard 24/7. He was always the first one through the door, always the first one to volunteer, the first one that people would call day or night for help or for advice. He was experienced. He was involved in every aspect of law enforcement. He was that guy that at the office that everyone looked up to and everyone strived to be like. The guy loved being a cop. As with a lot of officers like Corey, who law enforcement becomes their identity. One of the challenges that Corey had was he couldn't turn it off. He was a cop 24/7. And the job is already stressful enough the way it is. Add on top of that some of the cases we deal with and some of the things we see that we can't unsee. Corey struggled with PTSD after years of work in investigations, SWAT, task force, and other areas within law enforcement. He also had his fair share of serious illnesses while on the job, serious injuries while on the job, which developed into chronic pain that doctors were never able to really fully get under control. And Corey was one of those officers, one of those supervisors, one of those leaders that was always first to say, if you need help, if you need to talk, if you need to call me, you call me day or night, I'll be there for you. He was the one that was there for everybody. Unfortunately, as is often the case with cops like Corey and leaders like Corey, they're sometimes always the last one to ask for the help. And that is something that he struggled with. In the end, the PTSD from the job and his chronic pain from work injuries were too much for Corey to bear. And as Katie said, he took his own life on November 5th, 2019. I had the opportunity to, again, like I said, know him before, watch him through his career, working his way up, fast tracking through this crazy career in law enforcement. And I had the opportunity to tell his story with his wife, Katie, on the Officer Down Memorial podcast. It's a podcast that I produce and host that shares the stories of officers we've lost in the line of duty. Now, I understand there's always that question in the back of people's minds in regards to suicide and being sure there's a nexus to the job. Corey's case is a great example of a case where the nexus was clear, where nobody who knew Corey or his situation ever questioned that this wasn't a line of duty death, that his death wasn't a direct result of the work that he did and the service that he did for his community. And, so it's unfortunately, being on the Law Enforcement Memorial Association, I work with survivor families. I have the opportunity to work with survivor families and make friends with them. And, for them, we have traditionally done everything to honor their fallen hero. Unfortunately, for law enforcement officer families who've lost their hero to suicide, they're kind of the forgotten families. They don't get that recognition. And in some states, because it's still so taboo, especially with mental health issues being such a big concern today, in a lot of cases, they're not even talked about. They're not even recognized. And these families get forgotten, and then we forget the mothers or the spouses left behind, like Katie or her two kids. Where Corey served our community, served our state, and because of his service, he lost his life because of factors that nobody was able to get ahead of. Because of this, I'm so appreciative that this bill is being brought forward again, and really in support of seeing it follow through and getting recognition and support to these families who deserve it.
Thank you, Mr. Chair. I think that concludes my testifiers on this bill.
Sheriff, thank you for sharing your testimony with us.
Thank you, Mr. Chair.
Is there anyone else in the room that wishes to testify in connection with this bill? Not seeing anyone come forward. Committee have any discussion in connection with this bill? Senator Limmer.
Thank you, Mr. Chairman. Senator Seeberger, this is similar to what we attempted to do last year. I really like your bill. And giving credit to where credit is due, Senator Bigham was the first one to speak with Katie Slifko and brought it to our attention, and it was part of our bill that was included. I certainly am going to support this. I was hoping that if there is room on the bill for co-authors that you could add my name to it. And be more than happy to vote for it. Thank you.
Any further discussion? Members, we're going to lay this bill over for possible inclusion in our budget bill. So Senate File 1989 is laid on the table.
Thank you, Mr. Chair. Senator Limmer, there is a space for your name, and I'll make sure it gets added. Thank you.
Thank you, Senator Seeberger. Okay, members, last bill of the day here, Senate File 586. I'm going to hand the gavel over to my Vice Chair.
Senator Latz. Before you go on to the bill, it looks like you have an author's amendment.
Yes, Madam Chair, I move the A2 amendment.
Senator Latz moves the A2 amendment. All those in favor say aye. Aye. Opposed? Okay. Amendment is adopted, and on to the bill as amended. Senator Latz.
Thank you, Madam Chair. Senate File 586 authorizes prosecutors to initiate proceedings to lower the sentence of a person convicted of a crime that they prosecuted. It authorizes the Commissioner of Corrections, the supervising agent, or the offender to make a request to a prosecutor to review their case for possible action. It provides for the court to hold a hearing on the matter and authorizes it if the court finds that substantial and compelling reasons exist to modify the sentence. In making that determination, the court must consider the impact of a sentencing adjustment on public safety, including whether it would promote the rehabilitation of the offender, properly reflect the severity of the underlying offense, or reduce sentencing disparities. It provides for victim notification and input, addresses the service of the petition and what must be included in it, and what factors the court must consider when deciding whether to grant the petition. I want to emphasize that this is entirely discretionary within the prosecutor's office. They can choose to exercise this discretion or not to exercise this discretion with regard to any request that they receive to take action. With that, I want to commend to your attention the support of Violence Free Minnesota, which represents a number, and MnCASA. There's a letter in your packet in support of this bill. Violence Free Minnesota and MnCASA represent victims of relationship abuse and other types of crimes. And also I commend to you in your packet the Justice Action Network, which is a bipartisan criminal justice organization that's nationwide, and they have also submitted a letter in support of this bill. I also want to call your attention to the fact that they identified in there that a number of states have passed these kinds of bills, including in the last 3 years, Illinois, Louisiana, California, Oregon, and Washington State, and there are other states considering similar legislation. So members, I do have some testifiers that would like to contribute to this discussion.
Thank you, Senator Latz. We have John Schmidt and Sarah Florman signed up to testify. You can come forward. John Schmidt, if you could state your name, title for the record, and then begin your testimony.
Good afternoon. My name is John Schmidt. I'm an assistant Hennepin County attorney. First, I'd like to thank all of you for your public service. I've been here this morning since 8 a.m. and I see the work that you have done, and I know I couldn't do it. So thank you for what you do and for taking up this important legislation. I've been practicing for 20 years. I've been at Hennepin County Attorney's Office for the last 6. In that time, I handle appeals and I oversee our complex financial crimes team, white-collar crimes. The prosecutors are, by the Minnesota Supreme Court definition, must strive to be ministers of justice. That includes looking at public safety, that includes looking at victims, that includes looking at the defendants. And justice doesn't start when the charges are filed, and it doesn't end when a conviction is received or an appeal is finished. This legislation will advance the ethical mandate all prosecutors have to be ministers of justice. It gives prosecutors more tools in order to meet this ethical obligation. It provides important protections to ensure victims' voices are heard. It keeps the important decision-making on a local level where the elected officials are accountable to their community. And it allows judges discretion to approve or deny these applications. I've been working on a case for the last 3 years for a gentleman named Jerome Nunn, and he's been in prison for the last 25. His attorney approached me with his amazing story of redemption. And for the last 3 years, we have been working to try to get him out of prison. Now, Jerome Nunn committed a horrific crime, and he admitted that he committed this crime. It was first-degree murder and attempted first-degree murder. He's in prison for 30 years plus another 15 beyond that. Since he's been in prison, he has used his time well. He is now a mentor for people who are incarcerated. He has received 3 different college degrees, despite the fact that he went into prison with a 6th grade reading level. He's established programs that has been replicated throughout the state of Minnesota to help offenders and bring offenders and victims together to heal. He's also a pastor. One of the most amazing parts of his story is the mother of the decedent has become very close with him. She has forgiven him, and she supports his release. Despite this amazing story of redemption, we had no opportunity to go to court and ask a judge to release Jerome Nunn with the support of his mother. So we did try, and the judge says, I don't have the legal authority to do so. Now, I disagree with that, but that's the law as it is right now. Mr. Nunn has earned the support from my office, from the victim's mother, and he should be out of prison today, but he's not. This legislation would give us an avenue to help people like Jerome Nunn. And I ask that you support the legislation. Thank you. I'd be happy to take questions.
Thank you for your testimony. Sarah Florman, you may begin. State your name and title for the record.
Thank you. My name is Sarah Florman, and I'm the Public Policy Manager at the Minnesota Coalition Against Sexual Assault. MNCASA is a membership organization that acts as a collective voice of programs and individuals committed to ending sexual violence. Our 63 member programs serve victim survivors of sexual violence in all 87 counties in Minnesota. I'm here today to express our support of Senate File 586, Prosecutor-initiated sentence adjustment. Too often, sentences do not reflect the wishes and interests of the people or communities harmed. It's often assumed that people who experience harm always want a punitive response and the most severe punishment possible. And for some, this is true. Yet many victim survivors express a desire for healing and restoration for themselves and their communities, as well as accountability and sometimes even restoration for the person who harmed them. Most of all, victim survivors want a voice in the process. By passing this legislation, we can provide them this chance. Additionally, many incarcerated people are victim survivors of violence or abuse themselves. In some cases, that abuse was a contributing factor to their involvement in criminal activity. In these cases, based on what we have learned about coercive behavior and trauma response, prosecutors should have the opportunity to take those factors into account and recommend adjustments to sentencing. We know that locally elected prosecutors carefully consider the sentences they seek, but new information, perspectives, and time itself may prompt them to reconsider those decisions. By passing this legislation, we create a safety valve for prosecutors to recommend sentence adjustments based on the input of victims, the interests of justice, and other circumstances. We urge you to support Senate File 586 and provide this important mechanism for improving the criminal justice response and allowing victim survivors to be heard. Thank you.
Thank you for your testimony. Members, questions, comments? Oh, there's another member of the public who wants to testify. Bob Small. If you could state your name and title for the record, and then you may begin.
Thank you very much, Madam Chair. Members, my name is Robert Small. I'm the Executive Director with the Minnesota County Attorneys Association. And I want to first say that our association supports the concepts contained in this bill. our board would also like me to share some of the concerns that we have at our association. This past summer, many of our members met, as Senator Latz mentioned, this has passed in other states, and we met with our counterparts in California. And we had over an hour-long conversation about their experience in California. And after that meeting, many of our members, particularly our members in greater Minnesota, where there are smaller offices, there was a concern about resources and whether or not smaller offices would be able to handle the time, the intense time to adequately review requests that would be received. And there was concerns about resources. There was concerns about the Metro County attorneys having the ability to staff and process those requests that would come, as opposed to those smaller offices that wouldn't have those resources. And there was significant concerns about whether or not there was adequate justice being done throughout the state. And so during that process, the idea of a pilot program came up, and 7 of our county attorneys throughout the state, large offices, medium-sized offices, small offices, Todd County, Norman County, Olmsted County, Winona County, Hennepin County, Ramsey County, Anoka County. Those 7 county attorneys' offices volunteered to be pilot programs so they could gather data, develop best practices, and then share that information with the other 80 county attorneys to determine what the best practices, what the criteria would be. And so those data would be collected and shared. And so we ask that you take into consideration our concerns for this very important bill as it moves through the process, and thank Senator Latz for bringing this bill forward. Thank you.
Thank you. Senator Latz, do you have any final comments?
Madam Chair, I'll just note that if you look on page 2, line 2.1 and subdivision 3, it does specifically state that a prosecutor may review individual cases at the prosecutor's discretion. So it's entirely within the decision-making power of a prosecutor whether or not they have the resources or choose to deploy the resources to review individual cases. And paragraph C there indicates at the second sentence, a prosecutor is not required to respond to a request. So the prosecutor has the discretion to choose to simply receive a request and not take any action, including even responding. Now, they may want to send a letter. It might be appropriate to do that and say we don't intend to review it at this time, or we don't have the resources, or whatever they wish to do. But they're not required to deploy any resources at all. Yet, if a prosecutor's office does decide that they wish to review it, this proposed statute would give them the legal authority to do so. And so different county attorneys will take different approaches to this. I respect that. But for those that wish to be proactive about reviewing and potentially petitioning for resentencing in some of these cases, it's valuable in the interests of the victim's wishes, in the interests of justice, to have that tool available to those prosecutors should they decide to go through that process. So that's what I'm asking the committee to do.
Thank you, Senator Latz. Members, questions, comments? Senator Limmer.
Thank you. Senator Latz, in your bill, is there any minimum amount of sentence time an incarcerated person would be in, or a person being incarcerated for a minimum time before they are eligible for such consideration?
Senator Latz.
Madam Chair, Senator Limmer, no. This would not change any statutory minimum sentences that are already part of other criminal statutes. So presumably a person would not be eligible to be resentenced below that, I would assume, unless there was some discretion in the original sentencing process for that. I suppose theoretically a judge could conclude that the statutory minimum sentence in fact didn't apply, or that there was some exception that was not applied in the original sentencing. But no, the bill before you does not reach that level of specificity. It would be up to the prosecutor whether they wanted to seek that, and ultimately it's not the prosecutor's decision whether to resentence. It would be the judge's decision whether to grant the request for resentencing, taking into consideration the input at that point from the prosecutor, from the incarcerated person, and from the victim, who, by the way, will be notified to the extent that's possible to do so. The bill does require that the prosecutor, and this is on line 2.3, prosecutor shall make a reasonable and good faith effort to seek input from any identifiable victim and shall consider the impact an adjusted sentence would have on the victim. And I believe that there is also a provision for the victim to have input. Yes, at line 4.1, the victim of the offense has a right to submit a statement to the court, oral or written, at the time of the hearing as well, and the court must take that into consideration. So all the interested parties would have that. The judge would have the discretion. This doesn't mean that other laws relating to sentencing don't apply, just that this is a way to get in front of a judge, and ultimately it's the judge's decision. And the amendment that we adopted, the A2 amendment, does provide that the petition or the request for sentencing review shall be filed in the district court where the individual was convicted. So you could not have a situation where a convicted person finds a sympathetic county attorney in some other county to file a petition in a different county hoping to get a more sympathetic judge. They have to go back into the county where they were convicted to make the request.
Madam Chair.
Senator Limmer.
As I read this, my first impression is that it's kind of a roundabout, different version of a parole board without minimum incarceration stays. And so the way it's written, is it possible that on the first day of incarceration, the Department of Corrections Commissioner could recommend to the prosecutor back in the past judicial or a county prosecutor that this person should or could or should be recommended for less of a sentence? Is that the type of power we want to give to a Commissioner of Corrections?
Senator Latz.
Madam Chair, Senator Limmer, I suppose theoretically that's possible, but the probability of the Commissioner of Corrections doing that, and then the probability of the county attorney that had just achieved the conviction and the sentencing would go in and ask a judge to resentence under those circumstances, I would submit would be exceedingly low. And then the probability of the sentencing judge or a colleague of the sentencing judge in that short a time reversing the sentencing judge's own decision on sentencing is also exceedingly low.
Senator Limmer.
Are we, in this, would there be other circumstances that a judge or a prosecutor would consider in this, or are they limited to first the recommendation of a Department of Corrections Commissioner? I would imagine, I see that there's a list of things that are required to consider, but I'm thinking of something like perhaps there's an emergency in a family of someone who's incarcerated. Is that a factor? Outside of a behavioral improvement or outlook on life, whatever it is, a change of heart. We've talked about that on this committee, that people really don't change until they have a serious change of heart of how they react to life or how they have a different outlook. Maybe it's a family marriage coming up that they want to settle down finally. Maybe they just grow out of it, and by the time they're about 40 years old, they've decided this criminal behavior is just not really doing it for them anymore. Or maybe it's a religious conversion, or who knows what it could be. But there's some cause that is recognized somewhere that there's really is a change of heart with this individual. I think I can understand everyone will want to be released early, but what's the real deciding factor that a judge or a prosecutor should consider in this?
Senator Latz.
Seems like awfully subjective.
Yeah, Mr. Chairman, Madam Chair, Senator Limmer, ultimately, yes, the judge would have the discretion to do that. Keep in mind, it wouldn't get in front of the judge unless the prosecuting attorney decided they wanted to seek a resentencing. And then the judge has an open-ended determination to make, but the criteria that the court shall consider includes what impact, if any, a sentence adjustment would have on public safety, including whether the adjustment would promote the rehabilitation of the individual, properly reflect the severity of the underlying offense, or reduce sentencing disparities. And then in making this determination, the court may consider factors relating to both the offender and the offense, including but not limited to, but they may, and then the bill outlines a number, itemizes a number of factors that the judge, that are called to the judge's attention for consideration. Performance on probation or supervision, disciplinary record during incarceration, records of any rehabilitation efforts made by the individual, plans to continue those rehabilitation efforts once they are out of custody, evidence that remorse, age, diminished physical condition, or other factors have significantly reduced the likelihood of reoffense, the amount of time the individual served in custody or under supervision, and significant changes in the law or sentencing practice since the date of offense. Then the court has to find substantial and compelling reasons to adjust the individual sentence. So I would be very, very surprised, given all of the, I don't want to say barriers, given all of the criteria that are in here to slow the process down and provide for input and identify factors that ought to be evaluated. I'd be very surprised if there were any decisions that were made just on a lark or anything like that. It's not possible under the criteria that are set forth here that the judge would have to find. Will there ultimately, if this were to pass, would there be some situations where reasonable people might disagree on whether the judge made the right decision? Of course. Just like lots of people, reasonable people, disagree on outcomes of any judicial proceeding, sentencing and otherwise. But this provides a pathway for it to be, for there to be the discretion exercised where the appropriate standards are met. Without the pathway, the door is completely closed, which would not serve the interests of justice if someone were to meet all of the criteria and still not be able to achieve a reduced sentence. Say they had that religious conversion and they had the wedding coming up in their family and it's been 25 years since their offense. And they've demonstrated all of the proper, they've done everything right. And they get along great with everyone they should get along with, and the victim or the victim's family supports it. And yet they can't even get into the courthouse to have a judge evaluate whether they ought to be considered for earlier release. That's just a completely shut door. What it ends up doing is perpetuating in perpetuity, at least until the end of the originally given sentence, whatever that sentence was, no matter how long ago and no matter what has changed in the world and in their life. We are all different than we were 5 years ago, let alone 20 years ago, 50 years ago for those of us who are over 50. Yet, would we want a judge's decision that was made, or if we look back in our own lives, whatever decision maker made something that changed the course of our life for better or for worse, would we want that decision to lock us into who we were then for the rest of our lives, or at least some specified duration, period of time? Probably not. We would all want an opportunity at redemption and reconsideration, and all this bill does is provide an opportunity for that to happen.
Well, Madam Chair.
Senator Limmer, I'm going to allow Mr. Schmidt to respond as well, and I'll come back to you.
Thank you, Madam Chair. Senator, to add on to the Senator's comments in response to your question, at the very outset of any criminal case, the prosecutor has enormous discretion on what to charge. There can be a murder that could be charged as second-degree intentional, or it could be charged as first-degree premeditated. That same act could be a manslaughter. With that comes very, very different consequences. And what this bill would do is to add to the discretion of the prosecutor's office to allow that second look years later with the input from the victim's perspective, with the idea of public safety, and with a record of how this individual has done while incarcerated. And so it's another tool that broadens the discretion that prosecutors already have, but it happens at a later time versus at the very outset when a charge is being considered, when a plea deal is being made, or when prosecutors are asking a judge for sentencing in the very beginning.
Senator Limmer.
Thank you. In listening to the discussion, everybody changes over time. Longer the time, perhaps longer or more of the change. But if we get to that point and take it to the extreme, maybe we just have to shorten all the prison sentences down and nothing exceeds a certain period of time, just like the approach to probation now. Cap it out at 5 years, cap out incarceration at a certain line. Don't hold anyone for longer than, well, we're all going to change somehow. And you do change. When I've seen people change in prison because they don't have the same stimulus that they have on the outside. And so their world gets very small, and most people get into the routine, and there's not much left to exercise in that. That is part of a deterrence. It's part of a punishment. It's part of justification to the victim who's seeking some sense of justice for the loss of whatever they experienced. But as I'm looking at it, I'm thinking, and my concerns of prosecutors that don't charge. Of my interest in judges that seem to be exercising more often a downward departure than what sentencing guidelines dictates. And I'm wondering how those type of individuals would be looking at this newfound authority that we may be granting them. So just a cautionary note, I need to mull this around a little bit, but that's where my thought would be. Thank you, Madam Chair.
Thank you. And I've got a list here. I'm going to go to Senator Westland and then Senator Kroon.
Thank you, Madam
May I respond
Chair.
to Senator Limmer at some point as well?
Absolutely. Senator Latz.
I'll be very brief. I was thinking back to Mr. Small and the concern about whether or not there would be equity between greater Minnesota defendants, incarcerated people versus more well-resourced counties in the metro area. And it occurred to me that we just provided some funding to the AG's office for the prosecution or to assist prosecution where requested by county attorneys in greater Minnesota. We don't have an answer to this, but my question would be, if the county attorney assisted in that prosecution, would they also be able to help and assist in the review? And that may be a way to make sure that, again, we're bringing some equity throughout the state of Minnesota, where counties that are relied on the front end with the prosecution process with the Attorney General's office, that perhaps there might be an opportunity there for some assistance with the review process. Again, it's just, we don't know the answer to that question, I think, but it was just something that I thought about that might be a creative way to sort of address the inherent inequity based on resources.
Mr. Schmidt.
Madam Chair, Senator, the Minnesota Attorney General's office currently has a conviction review unit where they are taking a second look, and I've been a part of building that from the outset. Part of the mandate of the conviction review unit is to also look at sentences, and this would give the ability to do that. It would be up to the individual county attorney on the local level to decide whether they want to hear these petitions at all and what criteria they would like to be considered. And then after that process, they establish their own process of what they would want it to be. They could bring it to the conviction review unit. And in the past, I have represented counties in greater Minnesota because they lack the resources. I have represented counties all over the state, really, on appeal. And they are complex and very difficult crimes, and they didn't have the resources, and we were willing to step up and help. And I think that same assistance would be available, whether it's the AG's office or other metro offices, following the guidelines set by the local county attorneys.
Thank you. And Mr. Small would like to respond.
Senator Westland, Madam Chair, Senator Westland, I would just mention, as we talked with our counterparts in California, the California legislature, concerned about that, provided resources to county attorneys to do this. And so that could be an answer. Thank you.
Senator Kroon.
Thank you, Madam Chair. In the interest of time, I just have a couple of concerns that I'd like to bring up and maybe just raise it, then you can just respond to them rather than have it be a specific question. But I agree, we all know that the prosecutor's job is to do justice above all. And I understand that, but I've always understood that to be within the role as a prosecutor. And I guess this seems to me, it kind of redefines what a prosecutor is. And we're enlarging the role here to essentially include them as some sort of parole board or something to instigate parole. And I'm concerned about the expansion of the role of what it is to be a prosecutor. But to Mr. Small's point, I was thinking, this has been touched on a little bit, but I think he said he was concerned about adequate justice. I'm kind of wondering what you think about how this would do to consistent and uniform justice across the state, because I can see a totally different patchwork of counties where some counties are just going to absolutely refuse to do any of this stuff. Certain counties are going to jump in head first, and we're going to have, it seems, disparate results for how long people serve sentences depending on which county they live in. And just maybe you could respond to that concern.
Mr. Small, Senator Latz, or Mr. Schmidt?
Thank you, Madam Chair. Senator, that is certainly a concern, and I think that's something that already is happening in Minnesota because of the discretion that the prosecutors have at the outset in charging. And at the outset of charging, there are county attorneys. My old boss, Mike Freeman, used to not charge low-level marijuana offenses. Those offenses are being charged elsewhere in the state of Minnesota. And folks are, if they have a criminal history, they are going to prison for a while because of those charges. So this just adds to the discretion of prosecutors of when you're bringing charges at the outset, if you see a story of somebody who has completely rehabilitated themselves, and so many of the folks that are in prison are there because of substance abuse problems. And earlier today, we were talking about that scarlet letter. And if there is somebody who is able to show the amount of reform like somebody like Jerome Nunn has, despite the fact that it is a horrific crime, and he had substance abuse problems at the time that he went into prison, but so do so many other folks. And if they can show that reform and support from the victims' families, I think they deserve a chance to get into court and to make their case if they get the agreement of the prosecutor. Now, I also understand the parole board sort of concern that can come with that too. The answer to that for somebody like Mr. Nunn, he had 30 years plus another 15 behind it that he had to serve. So the parole board could look at him at the 30-year point and make a decision. They couldn't do anything because he has 15 years beyond that. This would give us the opportunity to get somebody like him who can do more good in the community than he can while he's in prison, to get him out and working for the greater good.
Senator Kroon?
Thank you, Madam Chair. Thanks for the response. You know, the fact that it's maybe already happening, this disparity between counties because of prosecutorial decisions, that actually is true, but this seems to me to exacerbate that problem if you add the back end to the disparities already on the front end. And by the way, you know, that leads me to my second concern, because I have noticed, I mean, we're in some county attorneys have taken it upon themselves. And granted, there's always been prosecutorial discretion, and I'm not advocating to get rid of prosecutorial discretion, but I've always understood that to be on a case-by-case basis, depending on the facts and circumstances of each particular case. And I just really don't like this trend of county attorneys just deciding whole categories of crime that they're not going to prosecute. I personally don't believe that's their job. That shouldn't be their role. And it really irritates me when I see them doing it. Which brings me to my second point. County attorneys, they're elected positions, okay? And so when it's presented, your mind automatically kind of goes to, well, it's going to be the same prosecuting entity deciding, you know, hey, maybe this person needs to be looked at again. And you're thinking, well, yeah, they prosecuted them in the first place. They might be in a good position to make that determination. But we all know that different people enter those offices due to elections. And so I'm envisioning a situation where there's a change in the county attorney. They come in, they disagree with what the previous county attorney did, and they decide not on necessarily a case-by-case basis, but consistent with what they're doing in prosecution already, they decide they're going to start reopening or using this new process for categories of crimes that the previous county attorney prosecuted that they don't agree with. And so it seems to me that this could get very political, some of these decisions. Do you share, any of you guys share those concerns?
Senator Latz.
Madam Chair, Senator Kroon, it already is. It already is political. There are prosecutors that will, in certain communities, they will not charge out certain kinds of crimes. In other communities, they will charge out those crimes. There's already a disparity around the state. You know, whether it's a blanket policy to not cover whole categories of crimes, or whether it's to say we're going to only seek sentencing of certain sorts in certain kinds of crimes, and we're not going to in other crimes. Each office makes those decisions for themselves. How much discretion they give to individual assistant county attorneys in deciding what to charge and what to ask for in sentencing versus how much of it's an office policy on penalty of if you disagree too often with, losing your job as an assistant county attorney. County attorney who's facing re-election in the next 6 months might be treating similarly situated case differently than they would have 3 years earlier at the beginning of their term. I mean, these are factors that come into play, and that's the risk or the benefit, however you look at it, of having an elected prosecuting authority in a county. And the same thing is with judges who are also elected. We have a sentencing guidelines system that is the model and envy of systems across the country, and certainly was one of the first in the nation. I think it was the first in the nation, attempting to create some consistency across the state. And yet, when we look at the data, there is still substantial disparities in length of probation, length of sentencing, and departure rates around the state of Minnesota. And that's been the explanation that has been offered by some of the senators in this room in support of mandatory minimum statutory sentences, rather than leaving it up to the discretion of judges and even county attorneys in deciding what kind of sentences to seek or impose. So I don't think you can ever take that out of the system. It's not in the nature of a parole board as I see it, because a parole board is a board that is at a substantial distance from the original community that is, and actors that were involved in where the commission of the crime occurred, the prosecution of it, the sentencing of it, and the whole bit. This bill would go back to those very same communities to evaluate the situation. When you get to the point of a resentencing, a judge could determine that early release is appropriate, but lengthy probation is still appropriate, and may not resentence in a way that shortens the overall length of the sentence. It just may shorten the overall length of incarceration within that sentence. So there's all of the types of resentencing terms and conditions would be on the table, except for making it more harsh, I guess, if you would characterize it that way, because there is a specific provision in here that says you can't go back and sentence them to longer prison term or longer probation, but below that, you could have a refashioned sentence that may be more brings the sentence into sort of today's conception rather than the conception of what an appropriate sentence was 30 years ago or 20 years ago or 15 years ago when the sentence was originally imposed. Mr. Small brings up an interesting question about resources, and we talked about the Attorney General's office, and which is already under-resourced in terms of how they're looking at wrongful conviction or sentencing review. But any county attorney now that is uncomfortable with the notion and wants to see what kind of experience there is could simply say they're going to wait 3 years and see what their colleague in the neighboring county had for an experience and what best practices. I'm sure the county attorney's office would be collecting information and developing best practices, and those who want to blaze the path ahead and figure their own way out, they'd have the discretion to do that. And those that want to sit back and wait and see what best practices are developed here in Minnesota or import best practices from other states, they'd have the opportunity to do that as well. No one would be forcing their hand on anything. This just opens the door for some discretion if they choose to exercise it.
Senator Kroon.
Thank you, Madam Chair. I understand you can't take politics out of the system entirely. I get that. But what you're proposing is you can't take politics out of the system, but you're proposing to expand that system. So if prosecuting decisions today are, in my view, overly political, in my view, the solution isn't to give those county attorneys more opportunities to be overly political on the back end in revisiting the sentences. But that's just kind of my philosophy on this. And then I also do think this is going to lead to more disparities, and then I suspect those disparities then will then be used for more sentencing reform, and as I'm seeing it, that typically results in more leniency down the road, and I can see that coming back to us. So I think we're creating a problem we don't need to create, and I'm just having a hard time getting behind this one. Thanks.
Senator Latz.
To me, Madam Chair, Senator Crewen, the exact counterpoint to that is that whatever sentence someone has right now, it's frozen in time. It's literally, it's in a deep freeze. It's a fraction of a degree above absolute zero in its ability to move. And that seems to me to be a deep inequity. If circumstances have changed or someone does the job right, and this is not a question of a motion to re-sentence based upon newly discovered evidence or anything like that. This is if society's mores have changed, if a person has demonstrated a substantial rehabilitation, things for which they can't seek a resentencing now, that they shouldn't be stuck with the frozen in place sentence that a particular judge or a particular prosecuting attorney imposed and maybe felt like it was rightfully done at the time. But how long is that supposed to last? If we're going to freeze those in time until the very end of a sentence, where's the justice potential in that? We always have the discretion as a legislature, if a request comes to us to make changes in sentencing. Sometimes we do that. We made a substantial change in sentencing 8 years ago, maybe, on drug sentencing. I carried the bill. We jacked up the penalties for kingpins. We reduced the penalties for the lowest level drug crimes. That was a legislative decision. It was a strong bipartisan vote off the Senate floor. We have the ability to reconsider those kinds of sentences if those requests come to us or if we decide to initiate that. But we can't be involved in individual cases across the state for every person that's incarcerated. That's what we have prosecutors and other players in the criminal justice system for.
Senator Limmer.
We do make changes from time to time in our statutes. The only difference is that we are a representative voice of the public. That's our job. And because of the pressure we heard from the public, we collectively made those downward moves. This is a little different. This is using administrators with the approval of a judge to make that without a representational input from our public.
Senator Latz.
Madam Chair, Senator Limmer, I would respectfully disagree. These are elected county attorneys, and these are elected judges, at least after their initial appointment. So there's a certain level of answerability to the public, accountability to the public that is built into our system, even though the ethical standards that are applied to county attorney, to prosecuting attorneys and to judges, constrain or attempt to constrain some of their decision making. Ultimately, they are answerable to the public, and if the public disagrees with the way they're approaching the exercise of their prosecutorial discretion or their judgment ultimately on the bench as a judge, the public can say, we disagree with you so much we no longer want you to be in that role, just like they can any of us.
All right, members, any other comments or questions? Senator Latz, final words.
I would appreciate this committee's support. I have enough trust in the prosecutors and the judges in this state to make, and crime victims in this state, to make informed input and decisions on these things where they think it's appropriate. I think there are enough protections built into this process to reflect not only public mores, but justice in the end, and that we ought to give this a level of authority, at least create the statutory space for these kinds of decisions to be considered. And that's what this bill does.
Okay, with that, Senate File 586 as amended is being laid over for possible inclusion.
Thank you.
And there is no further business, so we are adjourned.
Members, thank you for the very